Okay, welcome to Law and Licensing. We're going to go ahead and start, and we're going to start here in the front, Shonda, and we'll just move across like this, and just everybody can introduce themselves.
I'm Shonda Boss with Teaching and Learning. I'm Diana Sedgwick, Director of Teaching and Learning.
I'm Shannon Kearns in Teaching and Learning as the Gifted and Talented Specialist.
I'm Jolie Honey, I'm the STEM coordinator.
Whitney Gillett, Chief Privacy Officer.
I'm Brian Yazzie, I'm the Access Committee.
Corey Kahn, I'm with Financial Operations at the State Learning.
Jeannie Rowland with Teaching and Learning.
Travis Rawlings, Educator Licensing.
Nathan Ock, Early College, I'm Teaching and Learning. James Kaczynski, Western Governors University.
Holly Bell, FBA Advocacy, Counseling for the Introduction.
Brad AC, President AFT Utah.
Rita Hagran, VP AFT Utah.
Sarah Jones with UEA. Janice Ford, USBE.
Gary Shoemaker with Utah Special Defense Association and USBE.
Eric Rohn with Utah Association of Public Charter Schools.
Catherine Cheshire, UEA Association.
Kurt Benjamin, Living and Serving in UVA.
Garrett Rose, Secondary Relay Specialist.
Okay, thank you. We have a full room. Okay, so the first thing on our agenda is item 2.1, external data request, and that would be Whitney.
Good morning.
Good morning.
We only have one external data request. It is at the state level aggregated, and the request is from the Ohio Senate, I believe.
State Legislature.
They said it's the Ohio Senate, yeah, the state legislature. So they're asking all the states for this information so that they can see what they want to do with the e-schools. So they're looking for our participation numbers, just counts of those enrolled, and break down ESL, economically disadvantaged, and IEP status. But that'd be at the state level.
So it's just like the numbers, not like anything else, just how many students are in.
Yep.
Oh, yes. Any questions, Brittany?
I'd like to make a motion.
Okay.
I move that we approve the data request for Allison Cozard from Ohio State, the Ohio State Legislature.
Okay, so the motion before us is to approve the data request from Allison Cozad, Ohio State Legislature. Any discussion to that motion? Okay, seeing none, we'll vote. All in favor say aye. Aye. Any opposed? Okay, motion passed unanimously. Okay, item 2.2, standards for pedagogical performance assessment. That is Diana and Shonda.
Good morning, Diana Sedgwick, Director of Teaching and Learning. We're here.
Did you want to connect at all, or would you like me to show?
Oh, you can show it. If you want to, that's great.
Either way, okay.
Yeah. I wanted to just set the stage a little bit before I turn the time over to Shonda, because we're bringing this rule, or it's not a rule, these standards to you in a little different period of time than what we normally do. The standards for pedagogical assessment are actually referenced in 2 rules and required by 1. So they're part of 301, which was passed just a couple of months ago, and then they're also referenced in 502, which is an older rule. In 301, that was passed just a couple of months ago, there is a deadline, and that deadline is that's a deadline on you that you set for January 1st. And so because 301 was delayed, we weren't able to get started on the standards quite as quickly as we'd hoped. So Shonda's been working around the clock, and she'll talk about that process a little bit to get these standards in place so that we could present them to you today so that the full board could see them in December in order to meet that January deadline. So normally we like to bring things to you after we've had a lot of public input and review and that kind of thing, and in pretty much, like, we hope when we come to committee that there's very few changes between that time and when it goes to the full board. This time we're anticipating that there could possibly be more change than normal, just because of how quickly we've been doing these. So I wanted to lay that out in advance, just so you kind of know that it's because of that timeline that you set that we're on this really rapid pace. I'll turn the time over to Shonda, and she can describe the process and the standards.
Yeah, so we convened a committee made up of members of the teaching and learning team here at the state office, as well as higher education, educator preparation programs, and community support as well from district LEAs. And that committee has met in person 3 times since the fall began. And as we've worked through and figured out what we need for these standards, we've come up with this draft. Right now, we are in the middle of getting our public input. We've got a survey that has gone out. We have some focus groups that have been working and will be working together to look in depth at the standards, remembering that these are the standards that assessments have to meet in order to be approved to use for these teacher licensing and advancement. We have narrowed things down to 7 standards, and obviously in the document you can see what those 7 standards are. We have focused in on the Utah Effective Teaching Standards, and that every assessment must be aligned with those. Especially we've focused in on standards 1, 2, and 3, 4, 5, 6, 7, and standard 8. We've also looked at things with the standards needing to demonstrate the entire teaching cycle, so that it is not just a data collection of lesson planning, but that we see it from design and preparation through the execution all the way to the analysis and assessment of the teaching and the implications that it has in future instruction and design. Our standard 5 focuses on ensuring validity and reliability, and standard 6, making sure that they are rigorous and challenging. And number 7, we want to, of course, protect the privacy of students, realizing that we will likely have some kind of video component necessary for an outside objective observation and evaluation. And so those are our standards that we've come up with so far.
Okay. Any questions? Board Member Warner?
Okay, so Diana and I have had a number of discussions about assessments. I am not a fan of what we have implemented, because we have a teacher shortage, and yet we have made it so difficult to get through an assessment. So I'm going to really want to see the end product. First, how much is it going to cost to be a rater? Because we found out it was $10,000 an administrator, and it seems like what I hear from administrators is all they do is assess anymore. They don't really get to bond with the students as much because you have all these assessments. So I have 2 questions. 1, what's the cost to be a rater? Because if it's going to be a big cost like it was last time, then I will fight against these. And second, do we have it to where teachers are not passing? The idea, like, I look at the way I'm in the middle of doing my appraisals right now for my prosecutors and my investigator and my advocates. It's a really positive thing if you asked any of my employees. Here, we have made it so rigorous that a teacher cannot pass that first time. They have 100 points, I believe, is what I found out. So I want to know the cost. And 2, is it going to be so rigorous that a teacher cannot pass it?
So, no, we want the teachers to pass it.
Okay, good.
Yeah, we're on the same boat there. So the standards are not the assessment. So that's one thing to understand that we have had to keep struggling with too, because the standards set what the assessment has to accomplish and has to look like. We anticipate at least 2 commercial products. So ETS has a product and Pearson has a product. Both of those products cost around $300 for the teacher who's taking them, and are then assessed at the level of the ETS or Pearson. So the rater cost, I'm not really sure what you're talking
It was
about.
almost $10,000 a teacher or administrator this last assessment.
So what assessment are you referring to?
Whatever the teacher assessment.
Right now, all of our teacher assessments are the Praxis.
Is it the
and-
educator evaluation
Oh, that's
system
what I'm
you're
thinking
thinking?
of.
So that's different
That's
than
something,
this.
that's completely
Yes.
different.
Oh, okay,
This-
then scratch that whole thing.
Yeah.
Okay, sorry about that,
Yeah.
guys.
Yeah.
And then just in terms of, and this is not in the standards, but in terms of, we will go through a process of setting cut scores.
Okay.
So we will get recommended cut scores, no doubt, from the producers of these products, and there could be more than the two that I just described too. We don't know. They just
Okay.
would have to meet the standards. And then we'll set cut scores later.
Okay, gotcha. Okay.
Okay, Board Member Brittany Cummins?
So if I understand correctly, the intent is that some may choose a box product and some LEAs may have the opportunity to develop their own as long as it meets these standards. Is that correct?
Okay.
Because this is the pedagogical exam that, say, somebody on an associate degree would have to pass in order to get their professional. And so an LEA could put together an assessment if they chose to,
Yeah.
based on these standards.
Yeah, if they can meet the standards.
So I guess the question I was curious about, as I read these standards, it feels like this is a portfolio type assessment for a teacher. Is there any constraint on either minimum or maximum time that these things would be shown by an educator to show competency in that area?
So that's not part of what we have in the standards. If that's something that you desire, we could do that. Typically, I think that the two products that we refer to are either like a 6-month or a full year, because you're right,
Culminating
they do look
project.
more like a portfolio.
I just worry that if someone tries to cram this in too short of a time, that it wouldn't really be able to, but maybe that would be part of the vetting process of, here's my assessment that I'd like approved, and they're trying to do it too quickly, and there's no way you can show or demonstrate in a very short period of time.
Yeah, from the research I've done with the two products that we know are out there, they kind of set their own timeline in terms of how long they have in between things to revise if need be, and between the observations themselves. So there is a time frame, a suggested time frame indicated there, and a lot of it is also dependent on the LEA or EPP program itself, in terms of, is this something that they want their senior year, or while they're student teaching, or as they go into that last practicum into student teaching.
So there is flexibility on when a student can be using this, so they can do this and use their student teaching experience to show or to demonstrate, et cetera.
Exactly.
All right.
Okay, Board Member, Lisa Cummins?
Hi, good morning. Question, you said number 8. What was number 8? It's not on my...
It's our standard number 3 that references the Utah Effective Teaching Standard 8.
Okay.
I think maybe that's what you're referring to.
Well, you said you went through 4, 5, 6, 7, and 8, and I was looking for number 8. So
Yes, 8. It's our standard number 3 that references
Our standard number 3, okay.
Effective Teaching Standard 8.
Okay. Tell me if this is appropriate, but do you add how teachers respond to parents? I mean, we had a huge hearing last night, about a rule that we have that we need to fix, and within the realms of the law. Is that appropriate to add that here, of how teachers then respond to parents who want to opt out or opt in or take the test? Is there that part of that in here or no?
Meaning a teacher's communication with parents and
yeah,
things?
association. Yeah.
It's actually something that's come up in some of our committee meetings, our writing committee meeting, as well as some of the feedback we've already started to receive, that a lot of people want some kind of collaborative communication aspect to the standards. It's one that we grappled with a little bit as a writing team and weren't quite sure how to get that demonstrated in an assessment, but it's something that we are willing to go back and revisit because we're hearing it from multiple sources and feedback.
One of the challenges, just so that you know, is that candidates for teaching positions will be taking this assessment, and they don't have classrooms of their own. And in some districts, they limit the access to parents because they prefer for the full-time classroom teacher to be the one who works directly with the parents. So we know that there are LEAs, for example, that won't let student teachers participate in parent-teacher conferences. And so
Sure.
we have to be sensitive to that at the same time that we're trying to beef up this collaboration, and working effectively with parents is definitely an important thing that teachers do.
Well, and that's what I'm saying. It's a preparation on to let these future teachers know what is coming and how to respond to a parent in this situation because of our laws the way they are.
Okay, seeing no other questions from board members, we'll go to public comment. We have Sarah Jones.
Sarah, you can use mine.
See, I hate to bump somebody out, but thank you.
Yeah, just, there you go.
Sarah Jones with UEA. I really appreciated the background, hearing about the public input process currently ongoing, because we haven't had a chance to submit comments prior to this, so I'll share some things that we'll probably submit in writing later, but we haven't actually received information about that, so it would be helpful to know how that public input is taking place or how that's being pushed out. Just a couple of thoughts. The second paragraph that kind of sets up what the purpose of the standards are, I think could be stated more accurately, because it says that, again, in the second paragraph, the purpose is to assess basic competencies of all Utah teachers, regardless of preparation program. And I think it would be more accurate to say of professionally licensed teachers, because the LEA-specific licensed teachers will not have to do this assessment, as I understand it. Do you understand where I am on the thing? So the second paragraph saying that this is really the route to professional licensure, not the route for LEA-specific license. It doesn't actually apply to LEA-specific teachers. So that could be clear. And then just two comments on the standards themselves, I guess clarifications really. On number 5, where it says demonstrating validity and reliability, letter G says that the assessment provider must provide candidate and program outcome data as requested by USBE. And that, I don't really understand what that means at this point, but if it relates back to teacher effectiveness data in any way, evaluation data, that would be a concern. So I think that's really just more clarification of what the intent of the data is that you're gathering. And then on number 7, the privacy of students, which is paramount. I think it's, right now it just feels very vague. There's no supporting bullets here, like there are on some of the other standards. And what does that really mean? What does it mean to protect the privacy of students? So for example, my understanding is that in New Jersey a few years ago, when they had EdTPA in place and that required a video component, that created problems because now you're videotaping a classroom full of students as part of this portfolio. So what's really intended by this privacy of students? Right now it feels a little vague, and some supporting bullets there might be clear on the direction that you're wanting to go. Thank you very much.
Thank you, Sarah. Okay, we have no other public comment. So any other discussion or a motion?
Well, I'll make a motion that we move it forward, but I would like to have what Sarah said about LEA-specific included in there. Well, wait a minute. I don't know if I want, hang on, scratch that.
Okay.
What is the candidate and program outcome data? Do we have any idea? Travis knows. So that could help before I make my motion.
Come on up, Travis.
Travis Rawlings, Educator Licensing Coordinator. In terms of the language of the standards, what it's discussing is the fact that you've got to remember this is not only governing districts but also universities, and so there are federal reporting requirements under Title II Higher Education Opportunity Act, where essentially what they have to do is they have to give a pass rates, like we do that right now. So we have to collect praxis pass rates for our teachers for that Title II report. And so what this is referencing is aggregated data. It is pass rate data typically, so it would not be individual educator evaluation or scores in those terms.
Thank you.
Thank you, Travis.
So we have a timeline, don't we? We have a deadline. Okay.
Yeah.
I'm trying to figure out how to word this then.
We talked a lot about the deadline. So the reason I'm asking Angie about this, it's your deadline. You set the deadline. We are trying to accommodate that deadline, but I don't know what it would mean for you to break your own deadline if you wanted us to take another month, and we're really comfortable with that. If you wanted to take us to take another month and come back with the changes and the public feedback and all that, that would be you breaking your deadline, not us. And so I don't know what that would mean.
Yeah, what would January, I think, is the deadline,
Yeah,
right?
January.
January 1, yeah.
Yeah, to speak to it. And I'm trying to remember this, Travis, and you can support me if I'm incorrect. So the new licensing structure of professional associate LEA base takes effect legally, meaning all the licenses issued after July 1 of 2020 will be under that system. But the rules take effect on January 1 of 2020. And the idea is that higher ed institutions and LEAs that want to prep their programs so that they meet the January 1, 2020 deadline need a lot of this information to be in place, including they need to understand for their school year, which will start 2019, so the July 1, 2019-20, so we're about, 7-8 months away when those students are going to start enrolling. These pedagogical assessment requirements will be part of that higher ed education class's requirements. And so the early, right? No? I'm wrong. Okay.
Travis?
See, that's why I said, Travis, correct me if I'm wrong.
So the original draft of the rules had this deadline at July 1 of 2019, so the coming July. The board chose to move that up to January 1, 2019. The individuals that have to complete this are anyone who enrolls in a program after January 1, 2020. So, but they need that time to create their own, to adopt one, to decide what they're going to do. That's what they need that year and a half, essentially, to do.
So what would happen if we broke the deadline, like, by a month or something?
So I think that the reality is it would be the risk of somebody suing the board for not complying or the superintendent for not complying with the board's directive. And my guess is nobody's going to do that, because who would do that? It would be your LEAs or your higher ed institutions. So I don't personally believe there's much of a risk. We could amend that. We could amend that, you know. I mean, I don't know that the board, it's not binding on the board. If anybody, it's again, it's your staff that's trying to, it doesn't bind you. If it were a statutory requirement, I'd be more concerned.
Okay.
It's more of a directive that you've given to your staff. So, if that makes sense.
Well, then I'm going to make a motion that we have it back to staff with some of those changes and bring it back next month with some of the staff input, from some of the public input.
Okay, so the motion before us is to direct staff to take it back and update them with some of the concerns from public comment. Any discussion to that, Brittany Cummins?
And I would say to extend the opportunity for public comment, not just the public comment that was here today, but to put it out for public, to extend it to public comment.
Okay, and to also extend the public comment. So that's just a committee motion. Nothing is going to the board. So are you good? Oh, do we have to vote on that? I think we have to vote on that.
Yes.
Yeah. So all in favor?
Aye.
Aye. Any opposed? Okay, motion passed unanimously. Thank you. Okay, item 2.3, R277-308, new teacher induction. And Ben and Travis.
Good morning.
Hello.
Do you want to start?
Go ahead.
Okay. So the rule before you right now is R277-308. It is intended to replace the current I requirement rule. The current rule is R277-522. That is the entry years enhancement. Those are the requirements an individual must create or must meet in order to upgrade to a level 2. Now, since the new system doesn't have that type of a level 1 to level 2 license, then this rule really becomes about the mentoring aspects and requirements for both the LEAs and the superintendent and directing them. So as we've seen before, and we've talked about before, that ultimately as we go through this process, we're going to move things around, we're going to refine things. You'll notice that some of this language is directly from the 301 that was passed last month. Because we're saying, okay, we put it in there because that's where we thought, but now that we're starting to see the bigger picture, we felt like, okay, that needs to be in the mentoring rule. When staff looked at this with stakeholders, we met with HR directors, universities, we met with a number of different groups. It really was a little bit about sending a message. And I know sometimes the board likes to do that, sometimes they don't. But ultimately, there was concern that if there was a board rule about mentoring, and then there wasn't, that sent a message to LEAs that mentoring wasn't important, which we don't believe is the case. We believe mentoring is essential, and so we've designed this rule with a couple aspects. The things that are still from 301, I can talk about those, but the new things that are in here are talking about that the superintendent is being directed to create a model induction program. So similar to the language where we said we're going to create a model preparation program that districts can adopt if they choose, we'll have a model induction program that districts can adopt if they choose. So the superintendent has that responsibility. And then the other aspect is the superintendent is directed to create mentor competencies. The competencies that a mentor must meet to kind of essentially standards for mentors, and then provide training to both mentors themselves and the principals who oversee mentors. And that might seem a little odd. Why are we bringing principals into this? But that's because when you're dealing with new teachers and retention and increasing skills, you have the principal, the mentor, and the teacher, and they each have to buy into their system and work together. The principal is ultimately the evaluator of the educator. The mentor can't be. You'll notice there's language in this rule that talks about the mentor cannot be the evaluator of the educator. But if the principal doesn't know how to handle that relationship with the mentor, then it can cause problems with the whole situation. So that's where the superintendent is being directed to create the competencies, provide the training for mentors and for principals. And again, it's optional. We're providing the training. They can choose to do their own. And then facilitating the sharing of best practices, which is another thing we're starting to see in these licensing, where the superintendent's job is to connect districts with each other to help them communicate about those best practices. That's the extent of my comments. I know there has been some concern. We would like to discuss that now. The superintendents, you'll notice in board docs that there is a draft 2 and a draft 3. The superintendents raised some concerns specifically regarding if you're. I'm gonna refer to draft 3 if that's okay for everyone.
Yeah, that'd be good. It's my draft.
So on lines 36 through 40, the superintendents were concerned about possible liability based on this language. One of the concerns staff has is this is the exact language from 301. This isn't a new thing, but we have an idea on that, so we'll get to that in just a moment. The other aspect is on line 25 and 26, where it talks about a professional learning plan differentiated for each educator. There is concern again about this liability that if a district doesn't do that or or they let someone go and they claim they didn't do that, that it enacts some liability to that district. Now, obviously, I've never been a superintendent. I've never been sued on an employment, so I can't speak to that. But ultimately, staff believes that differentiated should be there, that it's best practice. We don't see the liability, but we're kind of from a different view, so that really has to be decided by the board. On the other section, 36 through 40, rather than removing the entire section, the key here is where it says who shall, where possible. And the word shall does create some liability there. So staff would recommend making an amendment such that it says a trained mentor educator with a professional educator license who, where resources allow, shall do these things. And so the idea is districts and districts are not arguing about whether or not this is best policy. They're not at all. It's simply about the exact language that's in there. Staff feels it's important to have those things. This idea that release time for working as a mentor is a really neglected issue in districts, because we know when we look at the research, mentoring without release time really isn't mentoring. It's not effective. So we want to have the language in there for the board to emphasize the importance of that for the districts, but we are leery of creating some type of liability for the districts, and so that's where we're recommending some changes to the words, but obviously you as a board can strike it as you see fit or however you want to proceed.
Board Member
I didn't
Warner,
know
did
if
you have?
had something, if you were going to.
No.
Okay. So we'll start, if we're looking at draft 3, we have spent 2 years now working on licensing and trying to separate licensing from employment. So that's really the way that at least I would like to move, since we've done it for 2 years. The documented professional learning plan, I really just believe we need to leave it up to every LEA, every superintendent, as to what that documented professional learning plan is. I totally understand what you're saying about differentiated. I assume that they'll do that, but again, that's a employment issue, not a licensing issue. And then with regards to the lines 36 through 40, those are employment. That's just the bottom line, is we want them to do certain things. We want them to be assigned. That is an employment issue. And when Brittany first brought this up about separating licensing from employment, it took me a while to come around, but I've tried to really focus that employment is the LEA responsibility. We have the licensing. And then on lines 42 and 43, again, that is an employment issue. So that's the way I would like to move, is just completely separating it, keeping it very basic and minimum, so that LEAs can basically have that employment. They do whatever they want employment-wise, because they answer to their own local boards. And their own local boards will be able to direct them as to what they want and put in the rules. And the boards the local boards may say, you know what, we want to have them have release time. But that's an employment issue between the employee, the employer, and their board. So I would like to move forward on that draft.
Okay. Board Member Brittany Cummins.
So Travis, you mentioned that lines 36 and through 40 are somewhere else in board rule?
So they are currently in the version of R277301 that was passed by the board last month.
So exactly the same?
That exact wording, yes.
So if we strike it out here, then we would have to...
We would already be planning to revise, because we wouldn't want duplication there, yes, absolutely.
Okay.
That's what I was just going to say.
That's
The
what
thought
you're gonna
process was to amend 301 at one point.
Okay. So can I ask a follow-up question? So you gave a proposed option there. I guess one of my concerns on this particular line is the resources. So what if the best teacher you find, because it's resources and personalities, and as you talk about that principal, mentor, teacher, it's not just about, you're a biology teacher, you should match up, right? What if you say that's not going to be a good match in my school, And I really think, this English teacher would be a better mentor for this new biology teacher than that. And I think it just puts restraints that aren't necessary for the decision-making process of that school leader trying to do the best that he can to bring on and retain new teachers. And then I was just curious about but may not serve as an evaluator of the educator. And I know that that's trying to find balance. And so I'm just curious about the reason why that would be removed and what would be the pros and cons of, is there ever a case where a principal could and would be the best mentor or coach for a new teacher?
Just one thing to point out, the primary reason we're removing it there is if you look at line 44 and 45, we kind of put the provision in there twice.
Oh, that's right.
So it's that provision is still in there that they can't be the mentor and the evaluator together.
Can I respond?
Yeah.
So to answer the question, it's a very good question. And what we know from the research about mentoring is that if a mentor is formally evaluating a teacher, it completely undermines their role as a mentor. It essentially negates it. That you cannot simultaneously serve as a true mentor of an individual and that person's evaluator. So that's why the language was there. But, as Terrell mentioned, maybe that's an employment issue. So you may want to remove it. That's up to you.
Okay. Sorry, I know this is probably too specific of a question, but in that data, does it undermine it from the evaluator's point of view or from the evaluee's point of view?
It's from the research that I've read now, and I haven't read everything. just putting that out there. From what I've read, what it does is it undermines the relationship between mentor and mentee. That the mentor and the mentee have to have an honest and open relationship that an individual can't have with their boss. As much as we would like to think so, and we try to have those kind of relationships, ultimately, if I can fire you, there's things that you may have cause to hide from me, or it undermines that relationship. That's what I've seen.
Okay, seeing no other questions from board members, we'll move to public comment. First, we have Rita Hagren, right?
Hello, Rita Hagren, AFT Utah. We like draft 2 for the following reasons, many of which Travis has already settled my arguments. Yeah, sorry, I can go home now. No. So, the difference between draft 1 and draft 2 is that one edit, which made sense to me when I read it, to take it out. And to answer board member Brittany Cummings' question about this is, because I've been a mentor. My last year of teaching, I was a mentor for 5 provisional teachers. And the trust there, because if I'm helping you become a better teacher, you will tell me things about, I'm really afraid about this, or these other things are causing me problems. And you have to be able to trust me that I won't go running to my principal and tattle on you for those things, that I can help you build it and fix it before the evaluator comes in. So Travis is absolutely 100% correct on the research and on the relationship. Also, looking at the lines about the differentiation, we want to keep that in for the following reasons. Okay, we not create, from a teacher point of view also, so not seeing this as a superintendent from the liability issues. You're going to be having teachers coming in with the associate license who haven't had no experience in the classroom. And then you're going to have teachers coming in with a professional license in their first 3 years that have already gone through student teaching, and maybe like Aaron Wilson, who was the best student teacher I've ever had that I'd ever seen. Okay, they have different needs on what they need to do to improve. So having it differentiated for each individual candidate, I think, is essential to helping that candidate grow. Over the years, I've seen the candidates go in, so those 5 mentees that I was working with, some of, if it's cookie cutter and everyone gets the same thing, it's not going to meet their needs, and many of them are going to think it's a waste of time. just to jump a bunch of hoops to jump through, even though there are some for which those particular requirements are essential that they learn how to do. So I can see you starting with the board and the staff coming up with, okay, here's like four general plans or 2 or 3 general plans on how to mentor for dealing with the different situations, an associate versus a professional. And then letting, so you have a basic guideline to start with, and then letting the districts differentiate for their particular people. So it shouldn't be onerous. And again, everyone expects teachers to do it. Why shouldn't we expect the districts to do it? There is that aspect to it. And then looking down on line 36 to 40, it really would be helpful, because as a math teacher, I would go into an English class or a science class or some class that I have no experience in with the particular content. So what I like is where you say this is the best, this is the recommended if you can do it, if the resources allow, and if it's the best situation. So when Board Member Cummings brought up what if the English teacher with English teacher might be a conflict, and so you bring another teacher, that's, I think, dealing with the resources you have. But also going in and talking with them individually. I know having a coach, instructional coach, that's their job is great, because here I was mentoring 5 student teachers, 5 provisional teachers, and I had to give up my only prep period to go and observe them. And that may not be the class I needed to be observed in. And then I had to meet with all of them. And then where did my time go? And did I get compensated? Yeah. $250 for my whole year of mentoring. Not a lot, but again, it was something, But as a classroom teacher, I didn't have an extra prep period where I could have done that. Or having the instructional coach, where the instructional coach could meet with the teacher on their prep period and not be constrained to what my prep period was. Okay. I think that's it. Thank you.
Okay, thank you. Okay, Sarah Jones.
Did I say all your stuff too?
You said some good stuff.
Of course.
So I won't repeat what Rita said. Sarah Jones with UEA. I will just say one thing about the release time funding and the concern the superintendents have. It's a very real concern about a shortage of resources. We know we have a shortage of resources. I think the reason why it's important to have this a statement from the board, the standard from the board about release time, is because then you ask for funding for it. Right? If we just kind of ignore it and say we're not going to put it in the rule because we know we have a shortage, we're not saying, hey, this is what best practice is, this is what will make the difference, we're in the midst of a teacher shortage, we need to retain quality teachers, and this is our ask of the legislature, and they need to fund that. So I'd kind of flip it and say, you're right, we have a shortage, and that's a real difficulty for our superintendents right now. Let's ask for the funding to support a quality mentoring program and put it in the rules and expectation. So separate from that, I'm going to just talk about a couple of things that were unclear to me that haven't been addressed so far, and maybe can provide some clarifying language or some understanding for me. In line 15 on the definition of mentor, this is language from the existing EYE rule that a mentor advises and guides. And I wondered if that's the best language to really describe that mentor relationship. Could we use something more active, that they're coaching, that they're supporting, that they're training? Does this really reflect what we want mentors to be doing today? Understand that's what's in the EYE rule, but I think we could actually make that language clearer about that role of the mentor. Line 19, so the induction program applies to an associate license. My understanding is the associate license is for both a student teacher and for someone coming in alternative pathways. So is the expectation that the induction program, as laid out here with all the specific requirements, applies to student teachers who were there for 6 months or a semester? I wasn't clear on that.
Yes.
That appears to be an oversight on our part. The intention was for it to say, an LEA shall provide an induction program for all, for employed. There was supposed to be a part about employment there, so that it was, if a student teacher is not employed by the district, they don't have that responsibility. It's really on the program. But that was an oversight on our part.
Okay.
Yeah, that's a good clarification. Then, kind of along the same line then, my glasses on here. Line 26. So the LEA support in meeting the requirements, the induction program is to provide support in meeting the requirements of a professional license. But previously in line 20 and 21, that they are also doing the induction program for the LEA specific. So my question is how these two things intersect. You have to have an induction program for the LEA specific license holder, and yet the induction program has to help them meet the requirements of the professional license, but they're not required to meet any of the requirements of the professional license if you're an LEA specific license holder. So how do those two things intersect?
I can respond to that.
Yeah.
Apparently I didn't read this one closely enough, and that is on me, and I apologize. That was intended to be LEA support in meeting the requirements of a professional license for an individual that holds an associate license.
Oh, okay.
So on line 20.
Like 20, like extend 27 to say for an individual holding an associate license.
Right.
Who holds, thank you.
Okay. I'm not sure, let's see, line 31 is, I'm sorry, I'm looking from draft 1, so I hope this is the same line. Line 31, where it says that the plan includes ongoing training on educator ethics and special ed. So if that's not still line 31,
It's 32,
32,
yeah.
thank you. My question on this is, what is the definition of educator ethics? So prior to being licensed, everybody must pass the ethics review. So you take the ethics review test. It's undefined, though, what the board intends to be that ongoing educator ethics training. Is this issues like testing protocols? That's part of it. Is it issues like boundary violations? Is it issues like professionalism and dress and manners? That's a pretty broad characterization, and I think that might benefit from having kind of further clarification of what the ongoing ethics issue is you want to have addressed, because they will have passed the ethics review at that point. And not to say that ethics are not important, they're critically important. I think it just needs to be clarified.
Travis?
It's a good, Sarah's got great points today.
Thanks, Travis.
Not that
Just
she
today.
always does. She always does.
Yeah, thank you, Angie. One just today.
So here's why that was done. Because there is a board rule that references this educator ethics standards. I believe it's 515. But under the new system, we don't know what that number will be yet. So this is, again, one of those things that when we come back at the end and we need to pull all the strings together, we would want to reference the educator ethics rules passed by the board. So that's why it's not there right now.
So as even a placeholder, perhaps as referenced in rule without naming the rule?
That
I don't,
would be a
that kind of
horrible
thing.
idea.
Because to me, that's really wide open, and we're supposed to be giving, guidance to LEAs. What do you want them to cover in that? And the other thing I'll just say about that section as well is there are a lot of ongoing professional learning topics you could select for the LEAs to specifically continue to train on. These two are important. Special education and educator ethics are important. I would say there's a lot of other things as well. Why are these two things called out in particular? Are we missing anything? If the issue is, differentiation and all these things that were talked about previously on what individual educators need, yes, individual educators will need these things, but probably more as well, which kind of brings us back to why that differentiation of a plan is so critically important. You're expecting two specific things for every single educator, and there's other things that individual educators need. That differentiation is critical. And just My thinking was that this is called the new educator induction program. I wondered if it should say induction and mentoring, just even in the title. It's a lot more, when I think of induction, and maybe the superintendents would say I'm thinking incorrectly, but it's more the orientation, kind of that short-term initial when you start working, but we're really talking 2-3 years out. This is mentoring, and this is going to be your mentoring rule. Maybe the title should be induction and mentoring. So, thank you very much.
Thank you. Okay, Terry Shoemaker?
Thank you. Terry Shoemaker with Utah School Boards Association, Utah School Superintendents Association. I want to thank Travis for accurately representing our concerns to the board here. I'd like to emphasize 2 or 3 things I think are important to this. And I think Board Member Warner and others and Cummins have referenced there is a difference between employment and licensing. So you have to create the balance. You have to find the balance here. Do we want to tell the employers exactly what they should do for training? That's probably worth taking some pause and thinking about what that really means. Or are we trying to do what's required for licensing at these levels? Now you're talking about moving from the license of an associate to a professional license. That's important. It's significant. I'm not diminishing that. That you should pay close attention to. As it relates to these things, the superintendent's has been discussed major concerns about liability. I'm just going to explain why. Having been sued, employment suits more than once in termination cases, they often come down to 2 or 3 things as it gets down the road. One of those things is training. And so the question then becomes, what has the school district provided and what have you documented as to what it is that you said you would do and what you did, and what then the other piece that becomes significant is the performance of the individual as it relates. Now, we have law now that allows teachers to be terminated prior to them receiving this license that allows them to be more on a permanent basis. The challenge that this board really needs to think about, do you want to make it harder for school districts to get rid of teachers that need to go? That's one thing I think you need to think about here. So one of the things that's important for school districts is when we get in a situation where we know we need to make a change, we'd like to have less barriers rather than more barriers. That simply is good for parents. Most importantly, it's good for the kids. We need to be able to make those changes as rapidly as we possibly can. And in some cases, we get sued. And the people then say, you didn't do that right, and then we have to go to court to get that figured out. I want you to think carefully about this, the difference between licensing and employment. And the concern the superintendents have, and the reason we gave you the language of draft 3, is that we felt that the liability issues associated with those other pieces were going to make it more likely that we're going to have a harder time removing teachers when we need to remove them, which is an employment issue. So that is what our concern was. And that's why we made the suggestions we made. As it relates to best practices, these are best practices. We have no argument with any of these things. In fact, we aspire to these things. Resources become a major issue as to whether or not we can do this. For example, if we have concern about a kindergarten teacher, and it appears that we're going to have to remove that kindergarten teacher, is that kindergarten teacher going to have a problem with the fact that her mentor or his mentor was a 5th grade teacher or had been a 5th grade teacher all of their employment life? In fact, if you listen to kindergarten teachers, as I was a principal of an elementary school, they think in many respects, and particularly early childhood educators feel this way, that their education, training, and practices are significantly different than what happens in a fifth grade. That being the case, best practices and teaching standards should be about the same. That's what the standards tell us. We ought to be able to have teachers who are well-trained and well-versed and expert be able to work with all of them. But not all educators feel that way, and they will push those boundaries, is my point. So if you make it too specific here and those boundaries get pushed, then we are limiting the ability of school districts to make decisions on teachers that really need to be made. And I think the other changes that Sarah and others have suggested are probably okay. I didn't see any problem with those, but draft 3 is what we wanted to bring to you because we feel like it represents what superintendents feel is the right thing to do. No arguments at all about the role of mentoring, why mentoring is important, why it's significant. We don't want to be placed in further liability levels that can be avoided if we simply just change the language. Thank you.
Thank you.
Everybody had a chance on your
Yeah. Yep, we're good.
So, thank you, board member, Cindy Dixon, state superintendent. It's, I'm trying not to do this, but mentoring and induction are such a key component of the role of retaining quality teachers, and that's one of your 4 goals in the strategic plan. So, as you deliberate this, I want you to just consider a couple of things. I think I've been convinced that lines 37 through 40 can be eliminated without too much of an impact on what we're trying to do. But I would also just ask you to think about this role of the board when it comes to best practices in recruiting, retaining quality teachers. Most states have really robust language in their state code around and board rule, however that plays out in each state, it's a little different. But they have pretty robust language and requirements around mentoring and induction. We are one of those states who has very little in code and rule, and we're one of the few states who doesn't support that with funding at the state level. And so every time there's a report, Utah always gets dinged on our mentoring and induction and support of new teachers. And I think you do have an opportunity for some leverage in thinking about how you support recruitment and retention around mentoring and induction. And I'm not saying that you should dictate every piece of that, but to completely eliminate that in thinking about licensing versus employment, I would caution you about completely eliminating all of this and keeping it really, really basic around licensing, because mentoring and induction is that critical piece that moves people from associate to professional, and within that professional realm, as Sarah Jones talked about, it's so critical for quality retention to have good mentoring and induction. So I do think it is a leverage point for the board, and something that you, if nothing else, you make a statement about to the LEAs that you value it and see it as a critical part of one of your board goals of recruiting, retaining effective teachers. So I know it's a fine line, and it's where is that tension? I just want to quickly address something that board member Brittany Cummins said as well about the role of the principal. The role of the principal has this line of support that can get really blurred, and I don't want to discount that mentoring's part of that. So Steve Barkley's done a lot of work around this, and when you look at coaching, there's this continuum for principals that has mentoring in there, and we almost have to be really explicit with teachers when we're evaluating, using language of evaluation or mentoring or coaching. So all of those things are on that continuum. It's the official mentoring that was spoken about that is a different role. So I don't want to discount that part of what a principal does. That's a critical part, and they don't just evaluate, but they're mentoring and coaching to lead to better outcomes for the teacher. So both are important. Thank you for indulging me, Chair Bolter.
Thank you. Okay. Any other discussion? All I know is when a lot of people were talking, I just kept thinking about what was said in NASB by Chris, and I can't remember her last name. She came here. Okay, yeah. Don't tell her I forgot her last name. But about staying in our lane. And so I want to make sure that we're not crossing over into the lane of employment, but that we stay in our lane. And so that kept going like through my mind. So as we work on this, Board Member Lisa Cummins?
I think of the pot and the boiling water and the frogs, right? I was very much in agreement with Terry Shoemaker's comments. It makes me nervous watching New York's policies become more progressive, and now they can no longer fire bad teachers, and they actually have to hire them back if they are fired under Mayor de Blasio's administration. So it's I don't want to have Utah go in that direction, so I would be supporting draft 3.
Okay, Board Member Warner?
Okay, so this is going to be a really long motion.
Oh, great.
So be prepared. Okay.
You know I have to restate it, right?
Okay. So I would like to make a motion that we move forward on draft 3 with the following changes.
How can we do it clean where we make a motion to move forward on draft 3 and then we can make individual amendments?
We've done the board, the committee before has passed it forward, but then asked staff to prepare amendments for the next board meeting for when it's presented.
Which
would be a draft 4.
Yes. Do you want me to state those changes that I'd like to see?
I don't know
Yeah,
yet.
you want to do the changes first and then adopt draft 4.
There we go.
Okay.
Let's start making amended first before we adopt the draft.
So first, to change the title.
Okay.
From new teacher induction to new teacher induction and mentoring.
New educator.
Oh, new educator. It says on here, new teacher.
It's actually educator.
It's educator on the rule.
Yeah, it says that.
Well, yeah, it is.
So is that your first?
You know, my glasses don't work because I had that, after that car accident, I got to go have surgery again. Like I had a detached retina, so I can't see very well.
So.
Okay, so the first one is new educator induction and mentoring.
Okay, so the first motion is to change the title of the rule to new educator induction and mentoring. Any discussion of that motion?
Yeah.
Brittany?
So I apologize if I'm getting ticky-tacky on words, but one of the things that I hesitate with adding and mentoring is it actually takes out of the word induction the idea of mentoring, right? It separates them. And so if we're planning on moving forward with a positive induction program that we're outlining and supporting, then I would prefer that we leave just the word induction, because then it builds the word rather than separating it from something, because then it really does say induction is here's your initial training and we're going to mentor you, and it almost limits, I'm sorry, just when I start thinking about words, but it limits the creativity, the ability of the LEA to define here is induction, and it includes mentoring and coaching and hundreds of other things, not just here's your initial orientation the first couple of days and we're going to mentor you. And I think induction is a good word because it's inclusive of the idea of what it is that we're planning to do to welcome, retain, and to keep a new educator. So anyways, it's just word definitions.
But when you look at the definition of induction, it's talking about orienting them to something new. So I would like to keep mentoring in, but it's just I just look.
It's defined in.
Not in the rule, but.
Yeah, not in the rule. Yeah, that it's just.
Our working group that discussed this was thinking along the same lines as Brittany. They particularly liked the term induction better than mentoring. That's why we changed it. But just food for thought.
Oh, I like Sarah's idea. Okay, so we can all talk about it.
Any other discussion to Board Member Warner's motion? Which was to change the language the title, to say new educator induction and mentoring. Okay, seeing no further discussion, we'll vote. All in favor say aye.
Aye.
Any opposed? No.
Okay, well,
No? Oh, Laura
Laura,
Belknap's
okay.
on there. Okay.
Laura said no.
Laura, did you vote no?
That would be correct, no.
Okay.
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 So can I keep going?
Yes.
Okay, line 16 on draft 3, where it says to mentor means an educator with a professional educator license who is trained to advise and guide the development of a new educator. How about if we change that, trained to coach
Okay.
and guide, or add coach in there, advise, coach, consult, and guide. So it's a little bit stronger definition, advise and guide. I don't know how anybody feels about that, but I would like to add a couple of words so we strengthen that definition.
So did you want to add the word coach along with it, or did you want to strike out
And
advise?
yes. No. Advise.
Coach
Well,
and
we want to
guide?
do it in alphabetical order because I'm a little anal. We would say advise, coach,
and guide.
consult, and guide.
Okay. Okay, so on line 16, we would add the words coach and consult where it would read advise, coach, consult, and guide. Any discussion to that?
Sorry. Sorry. I get caught up on word meaning because I don't know what they always mean, but I know what my head thinks they mean. So when we use the word consult, so when I consult, I usually go to someone above me I'm consulting with because I want information. Or is it I consult with, or is it consult with, or is it to consult? Sorry.
You should have been an attorney.
Are you, so you're saying like the word consult is what you...
Is it the responsibility of the mentor to ask the new educator for information, right? I'm consulting
Consult
with you.
with. Yeah.
Sorry. What does the word mean? Look it up in your dictionary.
Think about it.
Yeah.
Trained to consult with.
That's true, because now they're being trained to...
Coach and development.
So we've got the word trained in there.
Right. So trained to advise, coach, and guide, maybe.
To seek opinion or advice.
Yeah, so I, as the mentor, am going to seek the opinion or advice of this educator. It would be, it doesn't,
So maybe
so, but it would have to,
it's after.
but this is the mentor's responsibility. Sorry, like I said, I get caught up on
To be a consultant, I guess, is what I was.
To be a consultant, right? So they
That
would
just
be
didn't sound right.
Counsel together.
to counsel.
To counsel, to advise. Yeah, we could.
Advise.
Because advise, we're
because
using
is the
advise
same
already.
So, sorry.
So,
Yes.
I think maybe what might help it is if you, after the who on the first line, you break it out. So you could keep it as mentor means an educator with a professional educator license who, so we'd have A, is trained to advise, coach, and guide the development of a new educator, and then you do a semicolon and, is available to consult with the new educator, or you just need something like that? Because then it
You
fit.
good with
yeah.
Do you like that? You could write it really quickly.
See, before you write it, let's see if it even passes.
Yeah, or if it, yeah.
So that would be an amendment to the motion.
Yeah, that's what I was reading.
To go in.
Is available to the new educator.
To train intensively. To train intensively.
No, that's why I said I don't know what the word.
Thank you. Okay.
The word consult.
So do we want to do the amendment, or do we want to keep it the way? Okay.
What was the amendment, just to
So
get
what's
rid
the
of
amendment?
consult? Sorry.
It's fine either way.
I haven't stated it yet. I'm just asking, like, do you want me to, or no?
We'll look at this to see what they...
Okay. Take a look at that. See if
I don't know.
Mentor means an educator with a professional educator license who is trained to advise, coach, consult with, and guide
No,
the
we take
development.
consult with out.
Oh, sorry. I was reading. Oh, so that's not up there. To advise, coach, and guide the development of a new teacher and is available to consult with?
To the new educator.
Available to the new educator to consult with.
Because we're trying to say the mentor is available, makes themselves available, right? No?
Yeah, no, the word consult is fine when we use the verb form, the transitive verb form.
No, sorry.
She's a swig. Okay.
So we keeping consult.
Okay.
and-
It's fine.
Okay.
Okay.
Sorry.
So there is no amendment. So the motion before us is for line 15 and 16 to read, mentor means an educator with a professional educator license who is licensed to,
Trained to.
who is trained to advise, coach, consult, and guide the development of a new educator. Any further discussion to that motion? Are you good? According to the transitive verb definition. Board Member Warner, did you have any other discussion of that?
Nope.
Okay.
Just going to keep going on after we vote on
Okay.
this one.
All in favor? Aye. Any opposed?
That would be an aye for me, not opposed.
Okay. So motion passed unanimously.
Okay, on lines 18 and 19, it would be whatever Travis was saying it was supposed to say. An LEA shall provide an induction program.
To an employee who?
Yeah, you know what I'm talking about. How do we put that?
So how do we direct staff to?
To an employee who?
Fix that language?
Can we direct staff to?
Can we direct-
To prepare amendments to do that?
Yeah.
Okay.
Thank you.
So
I'd like
for,
to direct staff to, and make a motion to direct staff to work on that line so that it's clear it's separating student teachers from employees.
okay. Okay, so for line 18, we'll direct staff to change the language so that it's clear that it's talking about employees. Okay. Any discussion to that motion? Seeing none, we'll all vote. All in favor? Aye.
Okay, then the other.
Any opposed? Hold on. Laura?
Aye. Aye.
Okay, motion passed unanimously.
Okay, and then on lines 30, it's on line 32, ongoing training, and leave out educator ethics and special education, because we'll leave the professional development up to the LEAs.
Okay.
So it would just say ongoing training.
So basically on line 32, you want to strike out educator ethics and special education. Okay, so the motion before us is on line 32 to strike out educator ethics and special, to strike out on educator ethics and special education.
Can I say something about that?
Any discussion to that? Yes.
Yeah, I'm not saying that we shouldn't have that. What I'm saying is, and I agree with Sarah, we have the educator ethics they have to take, and until we figure out what we're moving forward on with ethics, I think that we need to just take that out until we can finish it, and we can come back and revisit that.
I'd probably suggest if you're going to do that, just striking that whole line because you already got the documented professional learning plan.
Okay.
I don't think you need a separate line that just says
Okay, then we'll just strike line 32.
So just strike out, okay.
Mhm.
So the amended motion now is to just strike out line 32.
Well, no, so we're reviewing somewhere the ethics. We can always go back in and add that in once we figure out, but right now, the state requires an ethics test, and then that's pretty much it. LEAs can do whatever they want with ethics, but until we figure out what that looks like, I agree, we've targeted two different areas only, and there are a slew of other things that probably could be targeted, but we'll leave it up to the LEAs, and then we'll continue working on the ethics piece for the state board. What does ethics look like?
Okay. So the motion before us is to strike out line 32 completely. Any discussion to that? Seeing none, we'll vote. All in favor? Aye.
Aye.
Okay, motion passed unanimously.
I think that was it for me.
Was that it?
There was something on line 27, but I don't know what I was supposed to say. I can't remember what I thought. I can't read what I meant.
What is it? It was for an individual who holds an associate license.
Okay.
Right. Was that it?
Yeah.
That's what I wrote, for an individual who holds an associate license. Okay. So I'd like to make an amendment on line 27 that we add for an individual who holds an associate license.
Okay. The motion before us is to make an amendment on line 27 to add an individual who holds an associate license. For an individual who holds an associate license. Any discussion to that motion? Seeing none, we'll vote. All in favor, say aye. Aye.
Aye.
Okay, motion passed unanimously.
Pass the draft 3 with amendments on first reading.
Do you want to make a motion?
Were you going to add anything? Okay. Then I'd like to make a motion that we pass draft 3 with those amendments and have, I'll just say it, leave it at that.
Approve R277.
To approve R277 308.
Draft 3.
Draft 3 with those amendments made.
Okay, so the motion before us is to approve R277-308, draft 3 as amended on first reading and sent to the board for approval on second and final reading, correct? Okay, any discussion of that? Brittany?
Yeah, I just wanted to share my thoughts on lines 36 to 40, because I think it's more than just licensing versus education, employment issue. Thank you. And liability, because I sometimes wonder as we write board rule, whenever we write a rule that's you could or you should or it would be a good idea if, or that it really isn't a rule anymore. It's here's a best practice. And so I think it's because we're saying that based on resources, which is just, it's very objective to an LEA to make those decisions of, well, this is our priority or these are our resources, and how do you say you did or you didn't have resources to do that. And so I think for me it's if we're not going to say you shall do this, then I think it's difficult to leave it in unless we really mean that that's something we require under this particular mentoring program. And so, but I do think that there are other ways, and we will be having model programs, et cetera, where we talk about those best practices, but to have a rule that says you shall, but you don't have to do something, I think is a little bit contradictory and difficult when you're trying to make decisions as an LEA of, well, how much do I have to do this, and how do I prioritize that based on all the other, if you have resources, here's a best practice to do, so.
Okay. Any other discussion? Okay, so the motion before us is to pass out R277-308 draft 3 as amended on first reading and sent to the board for approval on second and final reading. Okay, we'll vote. All in favor? Aye.
Aye and a hallelujah.
Any opposed? Okay, motion passed unanimously. Okay. Item 2.4, R277-707, enhancement for accelerated student programs. And this is Ben and Nathan.
Okay.
Oh, and
Garrett Rose is
Garrett.
going to join us too. So the amendments to this rule are a follow-up to direction that were given by this committee, I believe, back in April, to bring some changes to this rule. The rule deals with the enhancement for accelerated students program, which covers the gifted and talented AP and IB courses. And so we've made a number of changes here. I'll defer to Nathan to highlight any of those that he'd like to share with you, and then we'll be happy to answer your questions. You're on. You want the light.
You want the light on. There you go.
All right, I couldn't see it. Awesome. Thank you. I'm Nathan Auk from Early College and STEM Education Specialist from Teaching and Learning. And I just wanted to thank the committee for giving us the opportunity to share the work that we've done since April. Garrett was kind of overseeing the Early College and Coursework Committee previously, and recently our roles shifted in July so that I'm now the Early College Specialist. And so I asked that Garrett be up here with us to answer questions that are previous to that time period. So we were charged with increasing kind of rule clarity and enrollments for underrepresented students. During these last 6 months, we've touched base with stakeholders from the Access Committee on multiple occasions, school board reps, USBE internal staff. We talked to gifted and talented coordinators at several meetings. We chatted with subject supervisors as well as superintendents. And so we went through 4 drafts of this rule, the last of which is included in the board docs. And the specific changes kind of fall within 3 main spaces: the application process, distribution and use, and reporting. One of the big changes initially was to redefine acceleration to not just mean increasing speed with which students get content, but also to include depth, rigor, and complexity. And we did that by altering the definitions for accelerated student and acceleration within the rule. And then, in addition to the former expectations within the application process of defining how LEAs are going to use that money, they're now also asked to define what their parent outreach looks like with regards to serving underrepresented students, as well as the strategies that they're going to use to increase the representation of those students. Another directive of the priorities adopted in April was to shift the funding mechanism to incentivize LEAs to increase enrollments. And so what we did, the way that the funding works previously was to take a portion for IB off the top and then split the remaining funds 60% to gifted and talented programs and 40% to AP programs. And so formerly the AP allocation was based on the number of 3s that students achieved on those AP tests, and that has been shifted to fund LEAs based on the course completions that they have within AP classes. So there's another document in board docs that kind of lays out what the funding results were from last year, and then what we would anticipate the results being if we switch the funding mechanism to the process currently in rule. But the kind of overview of that is that big districts stand to lose a bit of money initially, but they also have the greatest capacity to be able to regrow those allocations, and small districts gain. From a percentage standpoint, big districts aren't losing huge percents, whereas there is circumstances where small districts can gain pretty large percentage, but their original allocation was small to begin with. In relativity. In this distribution and use of funds, the superintendent is also now given power to consequence LEAs who aren't seeing progress within increasing representation for whatever the circumstances of their LEA are. And then in this section, we also included a number of new kind of expectations regarding prerequisites. They were, in conversations with stakeholders, they were consistently brought up as a barrier for these students to be able to access classes. And so these prerequisites are things like GPA expectations, summer reading assignments, teacher recommendations in order to access classes and things like that. And they're specified within the rules language. So then the final section that changed was the reporting section. And so previously, LEAs were expected not only to talk about within their reporting the number of AP classes taken and completed, but also the AP test scores of 3 or greater. That was changed to 2 during this draft process because the College Board defines a 1.8 on AP tests as career and college ready, and it seemed as if that was the kind of the goal or the expectation of these classes is to get students ready to be successful within their college circumstances. In addition, the reporting requirements now include how they're doing in increasing representation of underrepresented students, as well as what they're doing to reach out to parents, and then finally to present those findings to their LEA school board. And specifically within this rule, we also now identify that they need to talk about the disaggregated subgroups from the state accountability system. And so over these 6 months, what the kind of spirit of what we were pursuing was to encourage LEAs to increase enrollment in courses to be representative of their student population. And I was struck by the amount of support that I heard from different stakeholders in this process, despite the fact that in some cases they're being asked to do things that they currently don't have to do. Okay. Is there anything else you want to add?
No, I think you hit all the highlights that that were definitely needed. Thank you.
Great, and I'm happy to answer questions.
What line is the incentivizing part? Where, because you said where LEAs will incentivize schools, or we will incentivize LEAs, or something like
Yeah,
that?
in
Where is
using
that?
incentivize, I was referencing the kind of shift in funding mechanism away from AP test scores into.
So where is that line
So that would be.
specifically in the rule? I'm trying to find it, and.
So-
40.
Okay, so I was in kind of the right area.
Is that the correct line?
Starting with 99 is where the kind of funding mechanisms are broken out.
Okay.
Through.
And it's divided with
1 to 12.
IB and then AP as well. So it talks about what we want to do with IB and how we want to allocate that funding as well as AP. So they parse that out.
I don't know.
So,
Board Member Lisa Cummins?
are you looking at, line 140 says an LEA may use to enhance accelerated student program funds for gifted and talented programs, including professional learning for teachers of, no, that's not what you were talking about.
No, he had just mentioned that
Yeah.
we were going to be incentivizing LEAs to increase enrollment in these gifted and talented programs. So I'm trying to figure out how are we going to incentivize it. And I have a concern with that because we've had discussions about other either charters incentivizing or whatever, and now we're going to incentivize. And so if we're allowed to, then where does it stop?
I think you could see that in kind of 106 through 110 is showing that they get the allocations based on their enrollment, so they get a bigger piece of that based on their enrollment. I think that's the language that you're referring to. Right?
That's right.
It's really hard to understand. Board Member Brittany Cummins?
Is it all right if I ask a few questions?
Yeah, it might answer some of the questions that are rolling around in my head.
Okay. So just curious, is it a typo on line 17 to have an A there? Differentiated and challenging instruction?
Yes.
Okay, so it's on line 21 as well. Good, sorry. Okay, so so I'm curious why the definitions for gifted and talented and accelerated programs are so different from each other. Is there a reason?
So gifted and talented has classically in practice for LEAs been based on roughly 3rd grade through 8th grade.
Okay.
And so there's a little bit of variation in how LEAs kind of define that, whereas accelerated or advanced placement programs are specific to high school. And so the kind of parameters surrounding how students enroll in courses are different in elementary, middle school versus high school. And that's why they're broken out and kind of specified.
So an accelerated program would be kind of the all-encompassing word that encompasses AP, IB, gifted and talented, is that correct?
Honors,
et cetera?
Yeah, et cetera.
Okay. No?
No, because it's
Into the mic.
Because accelerated has the meaning of going faster, whereas there are many programs in gifted and talented that are about going deeper or about special instruction or that kind of thing.
So in the definition on line 23, we're defining accelerated as increased depth, complexity, rigor. We're not talking about speed.
Well, and so
Right.
the last part is which may include
Include
above grade level
above
coursework.
grade level.
Mhm.
So
it's in addition to that. accelerated can refer to increased speed, but it's also now including these other possibilities for offering.
So I really liked the definition that you used for accelerated. However, the definition for gifted and talented, which seems to be just left the same, just gives the statement, assists individual students to develop their high potential and enhance their academic growth, which feels like a very general statement that you could really apply to any student in the system. And so I'm wondering, would it be wrong to bring in some of the parameters? If accelerated is your broad term and gifted is more your K through 8 or 3 through 8 term, could you use some of those same terms of depth, rigor, et cetera, in the definition for a gifted and talented program, so that it's not so general that we're just assisting students to meet their potential, which is everyone, right? Hopefully it's everyone, right? And so would that mess up anything in this rule if we expanded or changed that definition to increase to talk about that rigor and depth and possible acceleration?
No, not to my knowledge.
Okay. And also in that definition of, because I'm guessing one of the responsibilities of a program, a gifted and talented program, is to identify students, right? So they administer the program and they identify. So is that why it's broken out into two places where they assist students and then they identify students? Is that because there's two required elements of a gifted and talented program?
So part of the reason that identification is included is for the gifted and talented coordinators identified that there's, depending on the LEA, there's a small portion of students at the very top of kind of performance that are benefit from kind of special services in similar fashion to the special ed population that are identified towards the bottom for special services. And so we included rules connected to that identification in response to that feedback.
Okay. So would it be problematic then, as we look at this definition of a gifted program, to also change a little bit of that identification? Because we're just saying identify students with, sorry, and I apologize to everyone who's here today, but I have to make sure I understand the words, or else it drives me bonkers. So I apologize that I'm ticky-tacky about words. But identify students with outstanding abilities who are capable of high performance in the following areas. General intellectual ability. And so as I read that, I'm like, students who are capable of performance in, and you take out all the modifying words, they're capable of high performance in ability. They're capable of high performance in aptitude and critical thinking, and it doesn't, I'm not understanding the terminology on how that matches. Like, so if I'm trying to identify someone who would benefit from services of rigor and depth, et cetera, what is it that I'm looking for, right? Is it, sorry, that's my question.
So my understanding of the assessments that LEAs use to identify students who are included in those gifted and talented programs is not as high as Shannon's, who oversees that program. But recently, I know that we did a survey asking the process for how LEAs make those identifications. And so there's a number of kind of nationally normed assessments that are used. But with regards to the specific language, that was in rule previously.
Okay.
And so we didn't add anything in here with intent related to the charge of the board.
Yeah, and sorry, and I understand that these definitions weren't part of the change, but I really liked the definition that you did add, and that's why I'm wondering if that could inform maybe some of the things that weren't changed to really understand what gifted programs are meant to do, is to provide, because it's not just to identify kids, what does that mean to identify? Who is it that needs to be identified and who can benefit from those services and what those services are? That it's not just to enhance their academic growth, because that's every student, but it's really to provide, and one of the things I wrote down is to assist individual students to access increased instructional complexity, meet their accelerated learning needs, or to get, something that goes along the lines of similar to the definition that you had for accelerated programs. Anyways, and similarly in the identification of, are we identifying students who require increased depth, complexity, or rigor of academic processes or thinking areas, or something along those lines. So I'd be curious if that's going to cause harm to this rule or if it's beneficial, because I worry about the verbiage and what it is. So anyways, I am sorry, people. So.
Don't be sorry.
Okay, so then we get back down to line 63 and 64. It's talking about how, so an LEA can receive this money and they submit an application to the superintendent, and it includes their plan for. And so this is just a question, because we have LEAs who don't have a K through 12 program. They have a K6 or a K8 program. And so, but this requires that in an LEA's plan that they talk about their opportunities to meet elementary, middle school, and high school needs. And so is that I'm guessing it's intended, because LEA, when we think of an LEA, it's K through 12. But would an LEA who has a K6 program, if they're submitting this, is it just for their grade span, or would they have to talk about their preparation or their opportunities that their students would encounter in middle and high school?
Well, I think it would need to encounter specifically what, if they're K6, yes, address those needs, but how they are preparing them for the next step, I think would definitely need to be included.
Okay.
What kind of opportunities, that they're preparing them for if and when they move on.
To middle and high school. Okay. Okay, and then on line 114 and 115, it says if an LEA fails to demonstrate progress in meeting plan goals for placing and retaining underrepresented students in accelerated programs, the superintendent may. So is it the intention that, because they'll have to submit a plan, will these plans have to be approved? Is that correct? Yes. Okay. So is it the intention is when they submit this plan that they're allowed some time frame? So if you take, for example, so if you've got a K-12 program and you're looking at your increased enrollment in IB and AP and some of those things in high school, is there room in their plan to build up to that so you kind of have this growth curve, because you're starting in your elementary and you're going to kind of increase over time, or is it intended that you have to figure out how to increase high school this year and junior high this year and elementary this year?
So in the reporting, it actually mentions something kind of germane to that, where it says, let's see if I can find it. It talks about not only increasing representation, but also meeting LEA goals. So it's line 176, where it says LEAs is increasing enrollment of underrepresented students in its accelerated academic courses or meeting goals in its plan to increase enrollment. And so I think, as I understand it, that there would be the opportunity to see growth in those areas over time.
Okay.
Yeah, and we definitely want to allow time, because we can get LEAs to add kids, but are we looking at, are these kids successful in there? Are the supports there? All roads led to this board rule. We have a lot of supporting things that we want to do after the completion of getting this board rule approved. But yeah, we definitely want to look at some of those timeframes, because we want growth and sustainability. We don't want just growth for the sake of growth for a couple of years and then come back to the drawing board.
Yeah.
So we definitely want to give them some time to complete some of those goals and give them the supports that they need to accomplish that.
Okay. Last question. Line 119, 120. Sorry, it's not my last question. Line 119 and 120, it says an elementary school shall provide all course registration placement options to each student. And that line is repeated elementary, middle, and high school. And I'm wondering if on the elementary level, if we should add parents, because a lot of the decision making, it's not like if the students are filling out a registration card in elementary school, but any options outside of the normal classroom are usually made because of a decision of a principal, a parent, et cetera. So if we could add, I'm wondering if that would, okay, so anyways, this is my last question. Is on lines 123 and 127, we use the word prerequisite as, you can't require a prerequisite, and then we repeat that again in line 137. Do we need line 137, or is it important to reiterate that they can't use prerequisite courses?
That was actually something that when we talked to the superintendents about this rule, they had a little bit of heartburn over just including that language. I think, especially one of our charter directors that meets with that group felt like that imposed a high burden and might cause some issues. That might be something you want to think about, is how we want to include that. But they had heartburn with even putting that, because some classes by their nature, I think they felt required prerequisites, and this kind of got in the way of that.
And within our committee, we had a lot of discussion about the language of prerequisites. A couple of things they're worth noting. In line 118, it says subject to the general requirements of section R277-700-7. And what that rule talks about is that every student needs to get every piece of the core. And so, for example, if a student in 6th grade was asked, was seeking to go straight to 8th grade, they would have to demonstrate that they understood that 7th grade content versus just skipping it in its entirety. Because regardless of what a student's circumstances or ability is, skipping core content, there's no research to suggest that that is an effective way to support students in being successful in the future. And then regarding that prerequisite idea, there was a lot of discussion and feedback from stakeholders about this kind of norm that we've seen in a number of subjects, but maybe most kind of notably in mathematics, where students get into tracks or ability groups, and the research has consistently shown that they're not able to get out of those tracks. So if you end up in a remedial track when you're in a middle school classroom or a high school classroom, that the chances of you getting out of that track and being college and career ready go down precipitously. And lately, there's actually also been a lot of research to suggest that many honors tracks, so above grade level tracks, are also detrimental to students' college and career readiness kind of potential.
Yes.
It's not a new question, just clarification on this one. So would it be appropriate then in lines 123 and 127, where we're talking about prerequisites, could it be prerequisite courses? Because then an LEA could say you need to show that you're prepared. An LEA may have the opportunity to say you need to show under this prerequisite competency that you are prepared for this course, but you don't have to take this course, and this course to get there.
There are other kind of prerequisites mentioned beyond just the coursework. And Ben, I'm wondering if does our addition of that line 118, does that cover?
No, I think, I don't think it when we were talking to the superintendents, I don't think the charter director that had the particular issue with that felt like it covered this when we discussed that. I think Brittany's idea is probably a good one, depending on how you think that fits with. If you think that addresses is too restrictive, you can. I would defer to you, but that would certainly be one option to address that.
Why?
Yeah.
State your names.
Because the prerequisites include more than courses. So like Nate was mentioning, sometimes I'll say things like, you have to read the summer reading list before you can be in this class. And so adding courses then could make those kinds of things still possible.
Okay, so then that goes back to my original question. Then should we just take out in line 123 and 127 that whole line that talks about may not require prerequisites for enrolling, because then you come down
Yeah.
later and it talks about its prerequisite courses, and it talks about summer reading and all of those other things, because then it would reduce the confusion of what it means by prerequisites in that other line, because that's like any prerequisite, and then this defines it as a prerequisite course later, plus the other specific things.
So if there are all of the other prerequisites still identified, and we just add course to one of the list of those prerequisites, I don't think it undermines the rest of the prerequisites.
What I'm
As I read
saying
it.
is prerequisite courses already on one line 137, and so can we take out line 127? May not require prerequisites for early college, which is a course that would prepare a student for post-secondary coursework.
So the reason it's mentioned several times is to identify to all the grades. So Ben, can we remove any of those and still have that refer to all the grades?
Well, this refers to middle school and high school, that refers to middle school and high school. So I think what she's suggesting is absolutely appropriate.
So you're taking out line 127?
So I guess it would be 127 and 128 I haven't made a motion yet. I'm just asking if this is problematic, if we were to remove those, because then it becomes very specific later where you can't have a prerequisite course, you can't have summer reading, other things of participation, but it allows LEAs to be.
Can I piggyback off of that really quickly? Which I've been holding my question, is that have you talked to USBE on this? Because the prerequisites for early college enrollment for secondary math or higher math, you have to have all three, secondary 1, 2, 3, to have a college enrollment math course. Right, so if you're accelerated.
This is concurrent. This isn't concurrent enrollment.
This isn't concurrent enrollment, right? This is just.
That's correct. Sorry.
That would cover, because if enrolling in an early college course, right, you have to go then by what USBE says of what their prerequisites are.
So Ben, correct me if I'm wrong, but I think in line 118, that other rule gets at the requirements of having to have all those courses that fall within the core before you can access
Am I right?
corresponding courses. Is that right, Ben?
To some extent, yes.
Yeah.
You could pull that up if you want to refer to it. Or it's 700s on board docs for this.
And while she's looking that up, can I ask a clarifying question?
Yes.
Early college courses, is it related, is it the same thing or inclusive of concurrent enrollment? Yes?
So.
And AP.
As I understand it.
Yeah.
Is that broad? I don't know that that's clear in the rule. Because we're talking about,
So
I
instead of
know
early
anything about
college is
concurrent enrollment was removed from the rule, if I understand correctly. Because it's not part of the accelerated.
So concurrent enrollment is
Here, take the mic, sorry.
Early college in general includes concurrent enrollment, but this rule is only about AP and IB and gifted.
So it's not about, okay.
Can I ask a question?
Yeah.
Do you think it might be helpful that we define early? Do you think it sounds like that broad term is what's triggering. So either we could just state the courses we mean in lieu of saying early college course in the body, or we could define early college course. I don't know, either way.
Yeah, I'm comfortable with it.
So which one, sorry, were we just barely talking about? Which line was it, 119? No.
Sorry.
No, it's
127.
So may not require prerequisites for enrolling in, and then I guess we could just say AP or IB. Is that what we want to limit it to, or no?
If we take those lines out, I don't think early college coursework would even be in the rule anymore. Is that correct?
Which I think stops our kids from excelling.
No, it wouldn't
It would be
affect
out.
that. It would just take out the word early college coursework, and so we wouldn't need it because it's not relevant to the rule.
Yeah.
Is that
okay?
And so if we took out 123, 124, 127, and 128, and then just used the little I, to define what the prerequisites that cannot be used, then would that be sufficient and take out the ambiguity and confusion in it? I'm really trying not to mess up the rule.
So I definitely see course prerequisites in the high school section, and I think that
So,
the hope would be, and it shows up in the elementary section, and
so on line 134, in addition to restrictions listed in subsection D,
that's middle and high.
May not prohibit, yeah.
and so a middle school or high school may not prohibit a student from enrolling in a course based on a student's grade level, participation in passing or prerequisite courses, participation in passing. So it's all there, right?
Yeah.
And then, from an elementary perspective, an elementary school shall provide all course registration options to each student. Yeah, I think that would work.
So I'm just catching, are we probably, thank you. Are we then considering keeping the language on the lower one down here? I guess it's 130, no.
137?
137, but then striking 120, 324, and 127, 128? Is that
That's what
my thought.
suggesting, yeah.
recommended?
Yeah.
Okay.
As long as it doesn't mess anything up, I was just asking.
Do you think it does?
Because the language up above, because the language up above was more broad, I worry that now we have a specific list and we might lose things like teacher recommendation can be used for prerequisite, and now we haven't prohibited that. Or if I'm reading it right, if we take out all of the stuff above where it just says can't require prerequisites, and now we're defining prerequisites down below as participation in a prerequisite course or passing an honors level course, requirements over the summer, that list is not all-inclusive. That's just my worry, because we're really trying to shut down where people will put barriers up in front of kids for access. And so I just want to make sure we're not leaving any barriers out.
So,
Is it the early college coursework?
no, so here's my question, and you can clarify it if you want. But, so you're saying that there can be a student who should not have any barriers. So you're saying you shouldn't have to be able to pass a grade because it's not best practice to just skip content, right? But if you're saying that, then you're saying we're trying to take all barriers away. There shouldn't be any barrier to a student saying, I'm a freshman and I want to take AP Math 3 or whatever a senior would take, AP Calculus, right? And so you're saying there shouldn't be any barrier to a counselor being like, that's not a good idea for you to take that yet this year because you haven't taken Math 1, 2, or 3.
Right, so as Nate pointed out earlier, line 118 is the line that says you have to take the core coursework. Yeah. So there's nothing in here that excuses you from taking the courses that would lead to something.
Okay.
We still would hope that counselors would counsel students on whether or not they're likely to have success, but all too often it's the counselors who are saying, no, you're not allowed to take this course. Instead of looking at it in terms of counseling them, talking to their parents. And so the students who are being excluded are our students of color, are our low socioeconomic students, and the data shows that that's what's happening. And so to some degree, we are really trying to, it's a very bold move if you're willing to take that bold of a move, to say, we're going to take down the barriers, and if a student wants to take, and there are always logistical considerations too. Like you can't go in 7th grade and say, I want to take 10th grade English. That's not offered at your school. But if a student says, I want to be in the honors 7th grade English class, the counselor shouldn't be able to say, well, last year you got a D in 6th grade, so we're not going to let you do that. If the student has become motivated and the parents support it, then we want those barriers. That's what this rule says. So like I say, it's a bold move if you're willing to take it.
So may I ask my question? So then, are we prohibiting, if there is an 8th grader who wanted to take Math 1010, are we prohibiting them because they haven't taken the coursework of secondary 1, 2, 3?
So this rule doesn't affect concurrent enrollment, so this rule would not govern that.
Okay, so may not require prerequisites for early college. I mean, again, we'd have to talk to Yushi about that, right?
It's,
right.
So can I clarify? I think I understand what you're saying, but the line doesn't say early college coursework. It's for it may not require prerequisites for enrolling in an early college course, which is a course which would prepare for students for post-secondary coursework.
No, look at
which
line
is different. 121,
It's 120.
23 and 127 are different. So, because the line on 123, which is a middle school, so those are different, which is interesting.
Yeah. Because middle schools don't offer AP, IB, concurrent
But you
enrollment.
could go online, right? Couldn't you go online and do that?
I'm not sure.
Yeah, I don't know the answer to that.
I don't know.
Well, I know my son enrolled in an online course in middle school, but it wasn't an AP course. Oh, sorry. It wasn't an AP course.
And I don't know, is Corey still in the room? Are there any state online education programs that are available to 8th graders that fulfill college requirements?
Well, there are AP courses and.
Here, come to the mic, please.
We just had to bump Taylor up.
And introduce yourself, don't.
So I'm Corey Kant, the statewide online education program specialist for USBE. And there are a whole range of AP courses offered online through our program, and the program is open to students grades 6 through 12, where those 6th through 8th graders are functioning in a secondary environment. Statute allows concurrent enrollment? Yes. Concurrent enrollment as well, but so far, for reasons we'll address when we get to this next rule, they have not been offered through the program, but so theoretically, yes, those will be offered through the program as well. But the provider in the program is given the ability to judge preparation for coursework.
Okay. So if you're saying in line 123 and 127 are just across the board any type of a prerequisite, then why do we then try and define those prerequisites again down below? Why do we do that in the rule?
So the conversation at the committee meeting revolved, this section has been altered in several circumstances, and the hope in each case was to identify what the barriers were for that particular grade level. And so the reason that it looks different in each one is to kind of honor the fact that barriers look different for high school students accessing AP courses versus an elementary school student accessing gifted and talented courses in that grade band.
Does the code say that we need to remove all prerequisites? Because
This is not code, this is board rule.
Well, I understand that, but it's based off of a section of Code 53F-2-408, which says that we need to allocate money. And I understand the desire to remove prerequisites, but I do kind of worry about that, because then would we be setting out for failure? I mean, it's kind of like, if you want to do a gifted and talented program, I remember when I was in school, I wanted to do accelerated English, but my grades weren't where I could, and so it motivated me that following year to get my grades up so then I could. And I'm glad, because I would have definitely flunked out of that other class. So I'm wondering, and I don't see in code where we are being instructed to remove those prerequisites, and I am a little bit nervous in removing every single prerequisite, because if you do have a D or an F in a class, I don't know. I would hesitate to say, yeah, sure, go ahead.
So, Michelle, I'm going to play the devil's advocate on you here. Too many factors could have been in play for that year, for that student. And, if they're asking for it, I would think that, especially if we're moving towards a more personalized learning environment for a student, that, hey, if they're going to go for it, give them every opportunity, showcase that skill.
I understand that. I'm just wanting to make sure that, we don't eliminate, I just don't want to eliminate everything to where it's I don't want to set anybody up for failure in the long run. Or what do we do if they enroll in that and then it's okay, they're not keeping up, then what? How will that hurt them, or can they drop back and be okay, I thought I was ready, but I'm not? I mean, what is the plan for that?
I can speak to the conversations that we had surrounding this activity, or this circumstance, and what I heard both committee members saying, as well as feedback from stakeholders, is that those decisions are best made by the counselor, the parent, and the student in the kind of local circumstance. And so the circumstances that come up that might be challenging would be best kind of pursued within that kind of counseling circle. Or
right. I understand that. I just don't want an LEA to come back and say, sorry, you chose it, now you're stuck in it for the whole year, even though you're failing, because all of our other courses are full. So, I mean, I would hope that an LEA would allow them to switch, and I don't know. That's one of the... Go ahead.
What you just described as that counseling circle, would the lines 132 and 137, using the word prerequisite, be detrimental for that ability of a counselor to have that conversation with the student and their parent?
Right.
So I don't think I understand the question.
So using the word prerequisite on 123 and 127, would that hinder the ability of a counselor to have that conversation? Because now they can't use anything as a conversation starter of, you know what, this has been a struggle for you, or here's where we're at, here's what you're doing, here's some things that you could do to help prepare you for this coursework. I totally agree and get with the premise and the understanding behind this rule, because I was part of the committee that made some of the recommendations. I get it and I believe in it wholeheartedly, but it's when we get down to the very details of the words in rule that I have that. Public, I get caught up on what does that mean when we say something and we require something that is so tight that it actually becomes counterproductive to what it is that we're trying to accomplish. And that's what I'm worried about, is if we have it so tight that we're making it so that a counselor or a parent doesn't have the ability to be like, hey, here's what we can do to help you get ready for that type of coursework.
Right.
Then I think the conversation closes, because then that student is just automatically here. I can't, as a counselor, give you some benchmarks to work on because I feel constrained by this language. So the only option is, well, I guess we'll just throw you in the deep water and see how you swim. Especially as LEAs are writing plans to increase students in this. What does that plan look like? Is it going to be to create some of these scaffolding and these ladders for students over time, but would that look like a prerequisite for a counselor or an LEA as they're writing that plan? If they're trying to increase students in all of these grade spans in this accelerated preparation, then how do we do that in the best way that we're not actually hindering the process?
And then also in line 114, where it says if an LEA fails to demonstrate progress in meeting plan goals, so I don't want to put too many expectations on the LEA and requirements on the LEA, and then we're saying just let anybody come in. And I agree with Brittany, by no prerequisites, then what would that conversation even look like between the student, the parent, and the counselor? Now they can't bring up course grades in the past and say, look, in the past, with math, you've scored here, so we just worry. So, I mean, how would we even start that conversation if you're saying there's none?
So one thing that I would say that we talked about at one point in the process was this idea of may not require prerequisites for enrolling in a rigorous academic course, but that doesn't prevent them from having conversations surrounding the kind of evidence that's available to them. So,
See, I feel like it does. Because you can't require prerequisites, so as a counselor, I'd be like, well, I can't tell you now that you have to, I mean, I don't know, I worry about
If I may, I believe with what Nate's saying. I don't think it would stop us from saying, okay, here's the evidence. I can't stop you, but here's our concerns of why you wouldn't. The parent would also see that, right? There's knowledge there that I think would come into a conversation that is not prohibited in this rule. It's about advancing into the next class, not the conversation.
Could I suggest maybe some possible
Yeah.
wording? That if on line 135, if we said, well, it starts above, a middle school or high school may consider but not prohibit. And that way it makes it clear that they can have the conversation.
Where's that at?
That's line 135. Because the rule was not, when we were working on the rule, we never meant this to be, anybody can take any class they want, everybody jump in. That's not, so we want the process to be thoughtful. But we also don't want schools setting up artificial barriers and saying,
right,
because as board member Cummins said, there could have been something that happened last year.
And this is what we found in Christelle's case studies and
Right.
We've seen some really horrible
I actually like that because now I feel like, okay, they can bring up any concerns if a counselor has a legitimate
There's
concern.
some language that gives some leverage.
Right. And so, because as it was, I'm like, what if the counselor really does feel like, if we put you in here, we're going to set you up for failure, and that's the last thing I would want to do. And so, thank you.
So would we want to do the same on?
Raising hand?
Oh, raising hand. Yes, Laura?
Is it a good time? I'm just trying to fit in. And maybe this is a question for Diana, but has anyone taken time to talk to counselors and find out if we have been handcuffing them, or what would be the language they would like to see that opens the door without the floodgates, I guess?
So
Okay. We're going to invite Holly. Todd? Todd, school counselor. Up.
I'm Holly Todd, School Counseling Program Specialist here at the State Board of Education. One of my coworkers, Kim Herrera, has sat on this committee, and she has been out talking with school counselors. And when we go out to the schools, this is one of the conversations that we have with them as well. And a lot of times their policies are hindering their abilities to implement the opportunities for students to participate. So there has been feedback from counselors on the improvements that this could create for students.
Okay. And if we add in that consider but not prohibit, then would that
allow this counselor to have those conversations of, we really see the potential of you moving forward,
Right.
but you haven't met certain benchmarks yet.
We have some concerns or
we
whatever.
have these
Okay.
concerns, yes.
Okay.
I think that would be an excellent addition.
Okay. Laura, did you have anything else?
No, thank you. That gave me some clarity. Thank you.
Okay. Yes.
So so if you're adding consider down on line 135, how does that fit in with line 123 and 127?
Maybe add it there too.
May consider but not require.
Because that's the big prerequisite statement
Yeah.
that encompasses all considerations, and then we define a few later on, which still seems a little bit redundant, but I'm fine leaving it.
If we add may consider but not require, I don't know. But may not.
It's a tight
What does the word may mean, right? Shall, may, and that's, they cannot with the word may, right? And so,
No.
They may not, they may not. I mean, they can't.
they can't, exactly.
If they may,
They can.
They can't.
But if they may not, they can't.
They
Yeah,
can't.
shall and may.
Are the same.
Shall and may not are the two, like, controlling.
Okay.
May is the most
Right.
flexible.
Correct.
Um,
And so it gets back to that same point where we just still added that.
Right.
You may not require prerequisites. So even a counselor saying, I would like, before you enroll in this one, I would like you to take this course because I think it would benefit you, right? To have that, even to have that conversation with a student that says, okay, I know you want to take AP Calculus. I would recommend that we start here because of this history. And like I said before, I get what the intent of this rule is, but. Okay.
Yes.
When I look at lines 123 and 24 and 27, I'm looking at those on the systemic level. So a school may not say, in order to register for this class, a student must, and they're doing guidelines. I see lines 134 to 135 being really the student-oriented, the student-focused. So that's not the systemic piece, that's the individual piece. Whereas the other ones are more like the kinds of things that they would publicize or say, you know, that would have students never even consider taking the course because it was prohibited at the systemic level. But then when you get down to 134, you're really thinking about, well, now you're counseling about it, and now I don't have the prerequisite, so the counselor is going to talk to me about not having that prerequisite, and is this really a good idea?
Maybe, yeah.
Could we add a word that clarifies that this is a systemic type thing?
That kind of
an
separates
official
it.
prerequisite, or require a systemic or a registration or some word. Can I ask one question?
Yes.
When is this rule, I mean, is this is coming up because we are wanting to change it, right? There's no continuation requirement on it. Would it be beneficial to
Back.
bring it back next time with some of these thoughts rather
We
than
could
try and hash out all the words?
Meet again with our working group and
May I ask one question?
Yes.
Jamie,
Mike.
Sorry, I keep turning it on. Jamie, just on the financial part of this, because a part of this has a financial impact and will have a budgeting impact.
I believe it's required by state code too.
Well, yes, the program, and we already do have, this rule is in existence. We
Okay,
are
good.
distributing
So
the
we're
money.
good.
This is not a new program. I mostly wanted, and I wanted to just remind the committee, because it may have been stated and I missed it, but just as a reminder, this whole discussion started back in late 2016 when this committee made a motion for the group to do all of this work. And then last April, we received from this group a bunch of recommendations, which in general, the committee said we support these, go and do this work. And so a lot of what you're seeing in 707 today was as a result of the year-long study and work that Garrett mostly was spearheading until Nathan was assigned it and others. And so just wanted to give that background as a reminder that this has been talked about often. But one thing that we do need to be conscious of at the timing of when this gets enacted is that there may be some distribution formula changes, which would probably be, we would like to have kind of nailed down by what, March at the latest? Is that what you're thinking? I mean, so we still have time. I just want to keep that kind of goal in mind.
Sorry, Jamie Barrett, Minimum School Program Administrator. I need to have the budget done by no later than March.
Okay.
For fiscal year 20.
So this rule has to be approved.
So ideally, probably we'd want to have this approved by the board by January at the latest. February would be pushing it.
Okay.
But January would be ideal. So if you did bring it back next month, we have time then for it to go to the full board in January.
Okay. Yeah.
Thank you.
So could I mean, I know I've been talking for a very long time, but could we specifically articulate some of the thoughts that we'd like to see in the rule? And just, some of mine were just questions, but I think from me personally, and I don't know if we need a committee motion to see if the committee agrees, but I would think that the gifted and talented definition would be benefited by using some of more of the wording that was part of the accelerated.
So these are just committee.
So I move. Do we need a motion?
Do we
for the
need a motion? Can we just direct
Without
staff?
objection?
Okay. Say provide the feedback in general, and then
we'll
just the final motion you could make is just staff, please bring back an updated
Okay.
draft next month.
Okay. And then as far as the elementary requirements, that the parent be included as part of that, so it's not just that the student's receiving their program options. And then I guess it's just kind of coming, I think we've talked enough about what we're trying to get at as far as prerequisites, the defining and wording that prerequisite area so that we're not limiting the ability of a counselor and a parent to really converse and have that conversation about what's your best preparation line in order to get to your goal and to be enrolled, but not to put undue, like I heard a lot of the stories about what happens out there. And so I don't want that to occur, but how do we also not go the opposite direction and make it difficult for counselors to have a meaningful conversation with students and parents? So.
Okay. Okay, so do we need to have a motion? It's just, I don't think we do.
Staff will bring it back.
Okay, wonderful. Thank you.
Thank you for your time.
Thanks for listening.
Okay, item 2.5, R277-726, statewide online education program. Ben,
Corey, you want to come up?
Corey.
Michelle?
Yes.
This is Laura. I'm going to listen to the conversation. However, I'm going to recuse myself from the conversation and from voting on this. Thanks.
Okay, thank you.
All right, thank you, Chair. R27726 deals with the statewide online education program. We've made amendments to both this and the next item, which is R27700. The amendments here, in addition to doing some updates resulting from the recod, are primarily aimed at clarifying a number of provisions related to when students can get high school credit prior to the time that they're in the high school years of 9 to 12. Is that right, Corey?
Yes.
And I'll kind of defer to Corey. She can highlight maybe some of the reasoning for this and the motivations for that. But that's kind of what we've done here in these next two rules.
Okay, so I'm Corey Kant, the statewide online education program specialist. So as the program has grown, there has become more recognition that students grades 6 through 12 are allowed access to these courses. And we recently had a number of larger LEAs as they encountered students who either had taken courses in grades 6 through 8 or were intending to, said, we won't recognize that credit. And so it became something that we felt we needed to clarify in rule. But not only the fact that that credit needed to be recognized, but a process for recognizing that credit. So we've tried to do both of those things in our amendments to this rule. So I think let's just find the primary. Okay, and that's also why we're amending the graduation rule 277-700. So, okay, so if in our 277-726 you want to look at lines 168 through 173, this is the first place where we've addressed this. So, oh, yeah, I am looking at 726. Okay. So now we have two provisions here. A primary school of enrollment shall recognize that credit, so they're enjoined to recognize that credit for those kids in earning credits prior to grade 9 if the student has declared an intention to graduate early, and that simply means that they've engaged with the counselor to have that SEOP or CCRP, the College and Career Ready Planning document, so that these courses that the student's taking at that point in time are being considered and planned into the whole student's graduation trajectory. And the number, or on line 172, we simply took the line from our 277-700, which comes from situations in which a student is enrolled in advanced high school level, say, math courses. There was the requirement that the student would be enrolled in a middle school or junior high and a high school, and because that fully comports with the nature of this program, we just duplicated that here. Okay. Ben, you break in if...
I was just pointing out in that one particular section, I note that Superintendent Coleman from USDB did ask us to point out that he had a little concern with the requirement. I think it's in both of these rules that the student has to declare an intent to graduate early. Yeah, he didn't see the necessity for that requirement. Just so that would just be one point for the committee to consider as you're going through this, as to whether that's something that we need to include there. I don't know if there's a reason that you saw that specifically, Corey, but that was a concern he raised when we were discussing this yesterday.
Yeah, the reason that is included is simply to provide documentation that this was in the student's planning and that the student has consulted with their counselor. No other reason than that. So that's completely up to the committee to consider, their feelings in that regard.
Can I add a comment?
Yes.
Also, with their student information system, in order to claim more than 180 days of membership, they have to have that flag marked that they're on a path to early graduate, so they can earn more than 180 days.
And I'll just add something there, and I had not thought to talk about that. The reason that's important is most of these kids that are taking the courses in, say, 6th to 8th grade will be taking them in addition to a full course load. They won't be replacing their junior high or middle school courses. So it's important that the school's able to gain that extra funding. So that would be one reason for that. Okay. Okay, so when we move on to lines 180 to 188, we are simply providing a process for recording these courses, which are taken prior to the 9th grade. We're providing a process for recording those courses in the 9th to 12th grade span, both for purposes of high school graduation and for post-secondary requirements. So that if a student takes secondary math 2, is counted towards graduation requirements when the student hits high school, or if a student took Spanish 2 or Spanish 3 in, as many of our students will, during 7th or 8th grade, that when they get to college, that's actually on their 9th to 12th grade transcripts. So that's what you're seeing here. Are there any questions in that regard? Okay. Everyone ask questions if they have
Yes,
questions.
I do have a question.
Yes,
I'm just
go
getting
ahead.
to it. 358. Sorry. Line 358. The new language in 358 through 377. It feels like we're micromanaging an LEA opportunity to have a contract with a third party. And I'm trying to understand why, because LEAs already have compliance rules. So this feels extremely unnecessary.
Okay, and that's a very valid feeling in this regard. What we were trying to address was a number of providers that worked with vendors that they didn't have a contractual relationship with the vendor, so there were really no specifications surrounding that LEA's engagement with that vendor. One thing that meant was that because they were purchasing courses on demand and not on a contractual basis, they were utilizing teachers, licensed teachers of the vendor, but then they couldn't come and put those licensed teachers in our data systems. They couldn't report them through Cactus. And they weren't reporting them as well through SEATS, which is our data system for the statewide online education program. Now, once those courses or the educator credentials are reported in SEATS, that's a secure means of data transmission to our primary LEAs, which then place that educator credential information in UTREX for funding for those courses. So we were having a problem with the primary being adequately funded because a provider didn't have an adequate relationship with a vendor. So we were just trying to provide some specifics as to, outlining the relationship that a provider should have with a vendor. And one of those specifics is that
So,
yes.
Sorry to cut, it seems now that you're trying to govern the relationships between a third-party provider and their vendors. And that's,
No,
I'm trying to.
No.
Because the LEA contracts with a third-party provider. They've got their contracts. And LEA can put all these things in their contract. It just feels like we're,
Okay.
I don't like those lines.
And that,
I'm
like I
trying to
said, that's valid. But
It feels unnecessary.
the online provider that was functioning on this basis was working with a vendor with
Who is the online provider that we're referring to?
Provo East School.
So they contract, my understanding is they contract with My Tech High, is that correct?
They
So
were
is that who
actually
we're trying to
working-
govern?
no.
I'm just trying to
No.
understand this. Okay.
They were working with BYU Independent, buying
Okay.
courses off the shelf. So there was no contractual relationship between them. They could not monitor in any way the students' interaction with the instructors, the facilitators of those courses. And they didn't have a teacher under their own employment, which is an issue that you might consider, in any way supervising the instruction of those courses. So we were just trying to provide some guidelines here. They since withdrew from the program because it was very problematic for them.
Okay. I still feel like these lines are just micromanaging and we already have compliance rules. Do we not have, we have compliance rules. So this just feels really unnecessary. They should be compliant to the rules that we have and it shouldn't above and beyond. I mean, I understand what you're trying to do, but it just feels, I don't know. Yes.
So if I understand what you're saying is that the funding wasn't able to get to the LEA because the contract wasn't written correctly and the communication wasn't there between the LEA and the third party. And maybe we should just write in the rule that
we have compliance rules, so if they're following the compliance rules, then shouldn't the funding reach?
So
the LEA, I guess.
Okay, and here's another complexity that I think we should think about. The compliance rules are written for, not for this program, but for non-traditional programs, online education outside of this program, so those rules actually didn't apply to this program, and that's one thing that became evident. Yes, and this is taken from 418, but 418 doesn't apply to this program.
Trying to braid it together.
And we very specifically wanted supervision of facilitation and instruction by a licensed teacher employed by our provider, so that that teacher could be reported in seats to get to the primary for funding purposes, and also in Cactus so that we could judge the credentialing of that teacher.
My understanding was that they already had to have a licensed teacher.
They do, but
So-
if they're not reporting it, okay.
Well, and there's some distinction between the LEAs, the one providing the program, and the LEAs contracting with somebody else to provide those services for the LEA. So we're just trying to make sure that regardless of who is providing the services, that they're adhering to these standards. Just like with any other program that we have out there, we have the same standards. You have to be a licensed educator, you've got to be following core standards. There's certain things that everyone should be doing, and we're just ensuring that whoever is providing the SOEP services are following those same standards.
And it was difficult for us to judge if they were meeting those standards, because most of our providers will be using their own teachers. Their own teachers are in Cactus, and we can judge the credentialing. For this provider, they were using a vendor whose teachers were not their employees, so they were not in Cactus, and we could not assess their credentialing.
Are we
They may have been
talking about
licensed.
BYU? Okay.
Yeah. But we couldn't assess their credentialing.
Because there's other programs, yeah, that
What's the timeline on this rule? It's not immediate.
No.
So I wonder if there was a way to write into it, because then putting back on the shoulder of the LEA to make the decision if they want funding.
Right.
For okay, because I'm trying to think about the process of using the SEOEP. Is that right? SOEP? SOEP. So State Online Education Program, you have to access it through the state website, is that correct? Our website. And then there's different contracted, or you have access points through that point. So I guess my question is why would anybody be on that website if I click on there if they're not communicating in such a way to receive the funding through the channels that you guys have talked about?
Because when the rule and when the statute was formed and the rule were formed, there weren't standards like this, and we've had to build our standards over time. The standard for admittance as a provider was simply that you were an LEA. So we had a number of LEAs that were providers. We didn't realize till later on that there might be a problem between that LEA and a vendor, which might actually prevent a primary from being appropriately funded under this program.
So wouldn't that responsibility be on that? I'm guessing the primary is that person that you first click on, right? So
The primary has no control over this. Only the provider has control over
who's the
this.
define the primary?
The primary is the student's primary school of enrollment, where the student is in membership, will graduate, they retain all of the student's records and so on. And the provider is just the other LEA that that primary is interacting with?
The primary doesn't receive funding in this, I'm guessing.
So the primary gives up funding.
Yes, correct.
To the provider who's providing that course for the
Yes.
student that is their student.
Yes. So my question is could we just set up some standards that say, here's how you communicate if you want to receive funding? If you want to receive funding in this program, these are the communications that must be in place in order. And is that what this does?
And that,
Yes.
Okay, and so it's not saying, I'm going to make sure that you're providing this, but these are the standards. So you don't have to buy into the statewide online education program, but you can if you can plug into these specific things. Is that correct?
yes.
But an LEA already has compliance rules.
But
So it feels more like you're trying to govern the third-party provider rather than an LEA.
no, here
I
was the problem. You've got the basic separation between the two LEAs, the primary LEA and the provider LEA. The provider LEA has an incentive to place their educators appropriately in our seat system to gain funding. Okay, and it was our policy that they would do that in order to gain funding. They have to do that in order to communicate that to the primary LEA. Okay, the primary LEA is the one who, through our MSP specialist or program, is actually going to have to report those courses to UTREX accurately using the teacher of record at the provider LEA in order to gain funding. What was happening with this particular provider was that they were using BYU independent teachers.
So they weren't teachers of record.
They weren't teachers of record, and so the provider LEA didn't have teachers of record listed in all of the seats course records so that the primary LEA could place that in UTREX and gain funding for the courses that they had entered into an agreement with another LEA to pay another LEA for. So they weren't getting funded, but they were obligated to pay the other LEA if the other LEA offered the course.
Basically, we're just trying to ensure that, these students will pretty much have one-on-one access with whoever this provider is having for this educator to teach them. We want to make sure that that educator is background checked, that they're licensed and credentialed in the area in which they're supposed to be teaching that subject. And in order to do that, we've got to set some standards for whoever the LEA is that's going to contract with that provider to do those services and say, hey, regardless of, even in our normal LEAs, you've got to hold, our educators have to have these standards, and we're going to make sure that you have those same standards because you are providing services to our students.
Okay. My concern is that there are parents who use a third-party provider. I have family members that use it. My Tech High. They can do their own, custom build program, and the parent is the teacher. So are we then going to say, you parents, you now have to be a licensed educator?
No. The LEA should be, if they're contracting with MyTech to offer services, the LEA should have an agreement between them and MyTech to meet those certain
But you're
standards.
saying a third party, and you just explained that third party providers right here in this rule, they have to have licensed teachers because they're the effective teachers and everything. And I'm saying, what about that? Will that affect it? Because it sounds to me like it's going to affect it.
MyTech is not a provider for SOEP, so they're not included in...
They are not?
They are not a provider for SOEP.
Okay, I just want to make sure that we're not going to now tell parents, guess what? You have to be licensed.
No, MyTech isn't an LEA. Only LEAs can be providers. Yes.
Right.
So to the extent that one of our LEAs wanted to use MyTech as a vendor, they could. What this is saying is you have to assign a licensed educator in your employment to oversee
Right,
that
which they
interaction
already
and
do
be
that
the teacher of
again.
record.
They already do that. It's already being done because it's in the compliance rules that LEAs have to follow. So I'm trying to understand again why we have this. I guess I just am not, this feels just redundant and
So if you go to,
yeah.
if you go to schools.utah.gov Ed Online, it gives you the academic year, driver's ed, and summer programs of the school, the online providers. So that there are it doesn't look like there are very many.
Yeah.
So there's just a handful of them.
Yes.
Where did you go? Sorry.
Okay, schools.utah.gov/ed online, and it shows the online course providers. You're talking about no more than probably 10 because these are duplicative.
So then are we going to change the LEA compliance rules? I just am, why do we have those compliance rules then if we're adding?
Can you clarify what you mean by LEA compliance rules? Are you relating to another board rule?
Well,
Or-
my understanding is that LEAs already have rules that they have to follow in order to enter into contracts with anyone. And so I believe that these standards are already in there. So yes.
There are, every rule that we write requires compliance. So every rule is a compliance rule in general. And so there are rules that govern contracts with third-party providers, but this specific one is just talking about the funding that takes place, because it's not just an LEA and their contract, because their money has to flow from LEA over here, because this is where your student lives, and here's the LEA that's providing this. And so the money has to flow through the MSP from this LEA to this LEA, because this is the one that provided it. And there's funding issues that are required in our compliance, the state compliance, in order to pull down this MSP funding for this student and then to transfer it to the other LEA. So this rule basically just says, here's all of the requirements that need to be in place in order for this funding stream to function properly.
You should have presented my rule. Thank you.
So I'd like to make a motion that we approve R277726 Draft 2 on first reading and move it forward to the board for approval on second and final reading.
Okay, so the motion before us is to approve R277-726 on first reading and move to the board for approval on second and final reading. Any discussion to that motion? You guys? Okay, no, we didn't have any comment. Whew. Okay, then we'll go ahead and vote. All in favor, say aye.
Aye.
Any opposed? No? Oh, Laura's not voting.
I'm a no. I'm sorry, I'm a yes, because it's only affecting a couple, we're only talking about a couple schools.
And I forgot Laura recused herself, so, okay. We're at 2-2.
So, do we want to, there hasn't been any referred to the board, do you want any changes to this? I mean, do you want the staff to come back with any changes to this before, or do we want to, at this point, or?
I just have concerns with those lines. I need to think about it a bit more and research it a bit more. No, I don't, but let me think on it and then I can email it to you. I don't know if I want to necessarily strike them all out or just change it, so I just...
Why don't you email me, maybe we can bring it back.
Yeah, and because I'm not 100% sure on that, that's the only reason why I voted no. And so I just don't want to put more restrictions on an LEA and their ability to contract. And anyway, but I understand yours, so I just need to look at this and see. Okay. Thank you.
Okay, but as companion to that, we have the changes to R277-700.
Okay.
Do we we need to do anything as far as managing time here? Because you're at noon.
Yeah, we're at noon.
We've got a meeting starting here and several items to get through. I don't know if you want to address that at all, or...
I don't know.
What?
So, I apologize because I had stepped out for a moment, but was the motion to just table
So it was 2 to 2.
726?
No,
it didn't pass out of the committee.
And
It
this
was
is going to
there
be
was a
another
tie.
long committee
So
discussion.
the question is, yes, 700 is related. So if there is a potential, I think, for the board to take action on 726 in December, you may want to have the discussion on 700. They really need to go together.
Okay.
But if the other two, and I don't know that the other two are more important, but I'm just throwing that out.
So I just have a problem with leaving things dead.
Yeah.
So if there is something that you want to see happen with this rule that didn't pass out of committee, then I would suggest a committee motion to bring it back with some specific changes and have 700 come back at the same time.
Mm-hmm.
That way there's action and the full board, when it comes to committee report, knows that this is the direction we're going and may not take action on it. But if there's nothing specific and you just don't want it, then it's leave it and allow the full board to take action as necessary, because we can't just leave it.
Right.
And I'd be happy to work with Chair Bolger to
Yeah.
make a few changes if you think that would help us
I-
get this rule in the...
I mean, I don't know if striking out is what I want or changing it. Like, I need to think about it a bit more, and maybe the board will have.
So you want to move forward?
We could just move it forward.
Can I make a motion?
Yes.
I move that this come back to committee in December with, after consultations, to look at concerns with LEA and third-party contract negotiations, so.
Yeah.
And also to bring
And have-
back 700 at the same time as its companion.
Makes sense.
And then have we talked to LEAs and asked them, like, would this tie your hands in any way? What are their feelings on it? I would like to know.
We
Terry, you guys didn't have...
We discussed this with a group of school district and charter school people, and they, other than one person, did raise an issue of thinking that maybe we should, so it was Royce was talking about how we have this other rule coming and that maybe you want to tie the other rule to it. But he understood why it's in here.
Right.
Especially because the current 418, which is kind of the only other third-party rule we do have, doesn't appear to apply to this rule. So there is it's a little complex reason why maybe it does belong in here and not another. But we also may, by December, have the third-party rule, and we could then talk about all of them together.
Maybe we should just put those three only,
I feel
and that's
like-
it. No.
I feel like everything relates to each other. Yes.
Terry, did. Come on up.
We did talk about it, and much like this meeting here, there's a lot of complications associated with this. And I think the issues have been appropriately raised. It seems to me, if there's not a time issue here, I don't know, Angie, if there is, then it does make sense to me to make sure we're taking enough time to get the rule right. Do I think there should be a rule involving third parties? Yes. But let's make sure it's the right rule. Okay? How that's to be done, I think is it definitely cannot be done in a hurry. Okay? And you need to understand the full complexity of what all's involved, because there's a whole myriad of other statutes, as has been discussed here, that interact with those who do contractual services with school districts and charters. It's a whole myriad of other things that we're supposed to pay attention to as we create these contractual agreements. So getting that right, or at least attempting to get that right, will be probably best for everyone. That's my comment.
Okay,
Take the
thank
time
you.
to do it.
Okay. Yes, Board Member Cummins?
I would just maybe amend my motion to be like, that it comes back when it's ready, that not necessarily put the time restraint, because my motion was to bring it back in December, but just to leave that out and just say bring it back to committee.
And are we saying R277, 726, and 700? Because did you say that those two go together?
Those two go together.
Okay. So then the committee motion is that we direct staff to come back with R277-726 and 700, either in December or another meeting.
Board executive committee's discretion.
Yeah. Okay. All in favor? Aye. Any opposed? Okay. Item 2.7, R277-401, child abuse neglect reporting by education personnel.
Do you want me to jump in? Is that?
Oh, yes, sorry,
Sorry,
Debbie.
I wasn't sure. So Debbie Davis, Director of Internal Audit. So just a little background on this rule or where this is coming from. Based on some hotlines that we've been discussing with Audit Committee, there was a motion in Audit Committee that staff look at this rule and consider if there are any changes that need to be made. Again, I think this goes to, we want to get the rule right. Let's get our design right, and then we can work on implementation and monitoring that for effectiveness. So just an attempt to, let's just look at the rule. Let's see if there are things we can do better. And so looking at the rule, I posed some questions. I had talked with Ben about this, but really just not sure what direction, if any, the board would like to go on this. So maybe first stop here with law and licensing. You can see some of the questions that I've posed just to bring some clarification to the rule. And then as we get that feedback, we can take that back. Ben can take that and then put together some draft language to revise the rule if this committee thinks that's appropriate, and then take it to the board. So that's what's before you in the memo, just some questions that we had, maybe a little restructuring, chronological order of kind of how this would maybe work and be a little easier for someone in practice to walk through the rule and, oh, this happened, so I should do this, and then this, and then this. That's what's encompassed in the memo that has the policy questions.
Okay, any questions? Board Member Warner, did you have?
Oh, I'm sorry, no.
No. Board Member Belknap?
No comment.
And, if I could make one comment?
Yep.
I went with Sid and Patty to Indiana back in May, and legally, I can't remember, there was a professor from maybe Loyola Marymount that said federal statute already defines appropriateness and immediately, and there's there's federal law based on that we may want to look at.
Well,
You and I talked about it after.
Well, and the one issue I was going to raise in that regard is those terms come from the DCFS reporting statute. I think there may be some issue with the board undertaking to define terms that really fall into the province of another agency. Those are really...
Immediately doesn't mean, I'll give you the example on the federal statute. Was a teacher was doing some interviews, and in between an interview for a new teacher, a girl reported to have been sexually assaulted. The principal, it was a principal that was doing the interviews, waited until the interviews were all done, which was several hours later, and then went and reported it. And that was deemed not appropriate. That was not immediately. So, yeah, I think those are DCFS and law enforcement or criminal justice terms.
So can I just follow up with a question then? So coming into this, if you had a teacher, like my youngest sister is a teacher in her second year, she picks up the rule, okay, this is what I need to do. Does she know that? How does she know what immediately is? How does she know what appropriate notification is? What are the steps that have to be followed? Do we need to create a record that will need to be retained? Who does that go to? How is this monitored? That's what some of these questions are looking at, is for the practitioner who's our frontline staff, an aide, a teacher. My mom's a secretary, right? What does she do? Does she know what this means? I don't know that she does.
And I would say there, and to some extent, it may be something we need to go to the legislature for guidance, or we need to say, Human Services, you need to provide guidance on how we implement your reporting requirements. I just don't think that those particular definitions would be under the authority of this board, because that is a requirement imposed by the legislature and administered really by criminal justice, the Department of Human Services.
Well, and actually, I sent a PowerPoint out to all of my teachers in District 1 back in May, and it's defined under 62A4A 403 that they will immediately notify. I mean, that doesn't say stop, it's basically immediately, which I don't think a teacher should have any trouble understanding the word immediately. So.
Does our board rule reference that any code next to the word immediately?
Yeah, I think
I believe it does reference the DCFS reporting statute.
62A4A 403.
Yeah.
In the proximity of the word immediately? Or is it just in the, here's this rule, huh?
Up where it's authorized by, that's where it's referenced. Because it has the allowing appropriate access,
It does say
immediately notify, it says immediately notify.
Immediately.
But she's asking if it references the statute.
Statutes, so it's the bottom.
Yeah. Okay, so I would just suggest that, if we're going to modify the rule at all, that it just be minor and just be adding some type of a reference based on DCSF rule or law or state or something that's in the proximity of the word immediately that references them somewhere else to define that term, would be my only thought.
So maybe
Instead of trying to create a process of reporting, like through, because if I understand, reporting under DCFS isn't reporting to my boss, it's reporting to DCFS.
DCFS or law enforcement.
And so if we try or law enforcement, correct. And so if we try and put a process in place, it's going to complicate what's already there, instead of just putting maybe closely in proximity to the word immediately reference to. And so that way an LEA is their training, and LEA supervisors as they're being a part of the training of their teachers, they know what immediately means themselves and for training of their employees. So
it does say under 1B, it does reference 62A 4A 403, which is your mandatory reporting law. But what you're saying is maybe down here saying, any school employee who knows or reasonably believes that a child has been neglected or physically or sexually abused shall, pursuant to 62A 4A 403, immediately notify. Okay,
Yeah, we can do that.
that's a good idea.
So maybe one follow-up if I... Yeah. So along with that, as far as clarification, and then I think training is a big element of this. So do we need to be a little bit stronger than like the very last item, number 4, an LEA shall annually notify an employee of their legal responsibility? Does that need to be a little more specific as to what does that mean as far as notify? How are they notified? Should it be a more extensive training? And maybe it's happening and I just don't know. So just throwing that out there, what does that notify look like?
And I would think that's an LEA recognizes their liability in these types of situations. I mean, I think it's seen over and over and over again. And so I think they have to decide what that notification looks like to make sure teachers, so I think it's sufficient.
Any other discussion to this? Okay, thank you.
Helps.
Okay, item 2.8, R277-100, definitions for Utah State Board of Education.
Would you like me to go ahead and speak to it, Chair?
On draft 5, right?
Yes.
Okay. Yes.
I'm just pulling it up right now. So you may remember last month we were talking about issues that stemmed from some audits and a rule R277417, and you asked staff to go back and work on 417 as well as create a new rule about third-party providers, which we're hoping to get ready, and then board leadership or board executive could decide to have it maybe on December or January, depending on agendas and workload. But one of the other motions was for us to define homeschool student. And when I started to define homeschool student, I felt like that the other three definitions that are included in here of homeschool instruction, dual enrollment student, and online public school instruction were helpful to distinguish kind of what I would state are kind of none of this is clean. There's always a continuum of choice and placement of students, but to kind of distinguish homeschool student, which primarily or solely, it receives their instruction in the home. It's directed by the parent, and the state has nothing to do with that. And that doesn't generally, doesn't generate WPU money. A dual enrollment student, where the student is partially in a homeschool setting as well as participating in public school. So that way we could differentiate, if the student's taking 3 courses out of 8, to help the LEAs understand when or how much of the WPU they should be claiming. And then a full public school student, however, to distinguish a public school student who's receiving instruction in the home, so they are a public school student receiving instruction in the home, versus homeschool instruction, which is no public involvement at all, no oversight from public ed at all. So hopefully that context explains why I didn't just define homeschool student, because in some ways I felt like the important part of defining what a homeschool student was, you almost have to say what they aren't. So they aren't a public school, and then also to help explain to LEAs when students should be counted for purposes of generating a WPU versus when they shouldn't. So hopefully that background and context helps. I'm not saying I'm the expert in this by any means. This is a draft. If you hate every word of it, you are more than welcome to say go back and start from the drawing board. I just wanted you all to understand that also, because we can make changes as needed. So would you like me to start, or do you want, sorry.
Board Member Brittany Cummins.
So based on what you're saying is the purpose of it, can I make a suggestion or possibility? Because in the rule, we try and define homeschool instruction. We try and define what homeschool is not. Would it be easier to add a few definitions where we define, where we make it student-centric? So, because they're the ones that are actually pulling the WPU out at different points, right? And so if it was student-centric and we defined a public school student, a homeschool student, because if you read the law, it talks about a student attending a homeschool, and it defines what a homeschool is, right? And so if we were just to define a homeschool student is a student who attends a homeschool, as defined in blah, 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 blah code, right? And then you defined a public school student similar to how you have used the wording in the dual enrollment, where it's a student who fully is enrolled in, or whatever the words are under dual enrollment. Where is it? Dual enrolled.
Dual enrollment student means a student who is enrolled simultaneously in a private school or homeschool and a public school.
Yeah, so if you were to use that B part, where a public school student is a student who is counted by an LEA, fully counted by an LEA for membership purposes, blah, 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 right? And so you've got a public school student, and then you have a dual enrolled student who is a student who is somewhere in that spectrum between. And I don't know if we need to define what a private school student, because I don't know if it's defined anywhere in law what a private school student is.
None of these terms are defined in statute, which is part of the problem.
One is homeschool. Homeschool is very clearly defined.
Homeschool student is not defined. There's language about the rights of parents about homeschool, but the term itself is not defined. And that's why I tried to use that language in 53G 6204, but if you look at it, it doesn't say homeschool instruction means.
And so that was why I was saying a homeschool student is a student who attends a homeschool, because it uses the term a homeschool, because that's how, if you're going to fill out the form, blah, 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 in statute, it says you need to have it notarized that they're attending a homeschool, right? And it gives all that definition, not definition, but what that means, right? And so if you were just to say a homeschool student is one who attends a homeschool as articulated or set forth in da-da-da-da-da. And then if you were to have a private student, a dual enrollment student, as you have it defined here, and then a public student, a public school student is someone who receives funding, and so that would encompass what you're trying to say, not as you're trying to differentiate between online education in the home and not, because if you're pulling down full WPU and LEA, you're a public school student, whether it's in your home or not. And then you can leave your information about online education because it just clarifies that, but you don't need to say what a homeschool student isn't if you've defined what a public school student is.
That's sort of what I tried to do.
Understood.
But because these are really loaded terms, as you can imagine, and and then I just want you to kind of understand there's no malintention here, but these concepts are just talked about generally, but they've never actually been defined explicitly. So when you look in the statute about dual enrollment, it talks about this concept, but it doesn't define dual enrollment student. Same with homeschool student, it doesn't define homeschool or homeschool student, and I think that was on purpose. And so then it gets a tough job for us to then, and I agree, if there's anything we can do to make it simpler and easier, I'm all for it. So I'd be happy to try that. Okay. And like to just do those 3, public school student, or 4 it sounds like. So private school student, public school student, homeschool student, and dual enrollment student. And you think it would be better to just focus on the funding drawing, or maybe more?
Correct, because that's basically, especially when we're talking about dual enrollment and a public school student, it's not about location anymore. It's not about anything. It's about where the funding is going for services provided by some entity, right? And so a homeschool student, in the law, it talks about that they're not part of the compulsory education system,
they're exempt from
and
that.
it talks about all the things that they're responsible to do, similar to what you wrote in here, but we don't need to repeat it. Just say they are a student who attends a homeschool as outlined in whatever
I
law
think
that is.
just leaving it simple, a homeschool student means a student who is exempt from compulsory education requirements as described. Just leaving that and then striking out everything else.
And attends a homeschool.
Yeah, because that's what it says in law. It says attends a homeschool.
Yeah.
Okay, and then if you do a public school student is a student who, and you could make sure that you want to differentiate the full-time, or maybe it's a full-time public school student, I don't know what to do, but you differentiate between the dual enrolled and the full-time public school student who attends and receives an LEA or receives funding for that student. And then the dual, because dual means 2, right, or more than one, and so you're saying this is the differentiation, we're going to get part funding is being drawn down by an LEA for this particular student, similar to what you already have there. And then I don't know if we need to define private school student because we use that as part of what a dual enrollment could be in both in a private school and in a public school setting. So I don't know if the necessity. And then and then it makes the online public school instruction easier to understand because you're not trying to differentiate it as much. It's just like online public school refers back to that it's a public school. It receives funding through student enrollment.
The one thing, the rest of what after lines 64 down, they seem to contradict dual enrolled students because it's saying that a student who is counted by an LEA in membership, it's saying that a homeschool student does not include a student who is counted, but in dual enrolled student, clearly it is because up to half the time.
Yeah,
so that's why I'm saying I want to strike that out because it contradicts with what we're stating in dual enrollment.
But I see you're either a homeschool student or you're a dual enrolled student. You're not both. So I don't think they contradict.
I am I have homeschooled, And for the 2 courses my son took at Desert Hills High School, he was a dual enrolled student there. They got funding for it, but I still had to turn in an affidavit because it was up to half the time.
So the word dual means 2, and so you're enrolled in 2 things, right? So you're enrolled as a homeschool student. You're also enrolled as a public school student.
Right.
Right, and so that's why I think we need to differentiate but then the student, now as you put a hat on that student's head, they now wear dual, right? I'm a dual enrolled student.
Well, that's why I want to strike out this because
and I'm saying that we just kind of
does include a student that.
And I'm saying we should not worry about the specific lines, but kind of send it back to rather than try and define instruction and homeschool, that we become very student-centric and say, okay, here's a homeschool student, here's a full-time public student, here's what it means to be a dual student and a private student.
And I'm wondering if we should also maybe define, what's it called, split enrolled student?
That's in the financial, I mean.
What a split enrolled, that they are a student that.
Yeah.
They're a public school student, but they're enrolled now in 2 different, because they go to their public school and they do stuff online.
I can include that. Well, they're not always online, actually.
Right, they
Sometimes they're
may
in
go
2
to a charter
schools.
school, or they may.
Two different districts.
schools.
They could be a Canyons and a Jordan, but 2 different.
Now, I know for split
LEAs.
enrolled, on some cases, the LEA can decide not to allow that, right?
That's correct.
Because
But we'd
of the
just be
funding
defining the
But we would
term.
just be defining the term
And then 419 would say whether it's discretionary or mandatory.
May I
Board
say
member
something?
comments? Yeah.
Did you, I don't know who else read the letter from Representative Lisenby, but I mean, she just very strongly cautions not to define anything. It's not our responsibility or jurisdiction to start defining this, because I think then we're getting into bigger trouble that we don't want to ask for.
Well, she says to define it according to what's in statute.
Well, homeschooling and dual enrollment are well defined in the state
Right,
code.
and so we should
And she's
do that.
urging us to avoid establishing definitions of homeschool student, home instruction, dual enrollment,
Right.
and all of that. So I just
But we're
throw
not going to
very
do
big
home
caution.
instruction, right?
Yeah, no, that was my suggestion, was that we just reference code, because then in later rules, right, the purpose of this definition rule is so that every time somebody reads in rule homeschool student or dual enrolled student, we have a single point that we refer back to of here's what that means. Because it does have funding implications, but we have to fund students based on
Right, I understand
what hat they're wearing, what backpack they're wearing, because the funding is in their backpack. And so if we don't know what backpack they have on, how does the funding get to where that student needs to be?
So
And
again, I think because the funding comes from the legislature, I think it's the legislature's job to then clarify these definitions instead of us doing it. I just am very cautious of doing this.
Well, we've had a rule in place already for 19 where it defined, and was very much in code. My concern with this new one was extremely wordy, and then the homeschool instruction, we have no right to define that, but we're not going to define that in the new one, right?
Yeah, my thoughts are that we not focus on the instruction, but the student with the money backpack.
Right.
Right? Who are they and how does the money flow depending on where they're at and what they're doing? And so we're not defining homeschool. We're just saying here is what the code says about
Says
what
what a
homeschool
homeschool student
is,
is.
right? We're not trying to talk about what the instruction looks like above and beyond what's already in statute, but here's a student who attends a homeschool, okay, and so they don't receive funding based on that law here, and so that when we reference it in some other rule, so that it's clear that there's a difference between homeschool and online education that is a public school student. So,
okay. So then,
or would even just defining a public school student and a dual enrolled student be sufficient? Because if you're not a public school student with a backpack on, then
I know in Rule 419, homeschool student was defined, and we've had, where did it go?
And it's not a good one. Like, it's not accurate, I think.
I don't remember, now I can't find the line. It's pretty similar to what we were doing.
Can I make a comment?
Yes.
That definition, we've been told, creates confusion about when students are let's say K-12 online or whatever online school, but they're in the home, that definition actually fits or describes a student who is in the public education system and could generate WPU, but just happens to be
In the home, well, they
like,
are
while
a
they're
public school student. If you're in the home and you're doing an online public school thing, you are a public school student.
Right, but do you have that definition?
Yeah, homeschool means formal instruction of children, in their home instead of an LE. I see the
Yes,
difference.
so we've had
Okay.
confusion, and that's part of what, I agree,
Right.
we could just redefine it there, change that definition, but
I see what
that's
you're
when
saying.
we thought we would do it here, but.
Okay.
I would almost want to go that route. I think it's safer than having to do all of this.
We're not trying to do all of this.
Well, create definitions. I think I'm just cautious.
Just
Well,
419 is a
very
definition.
cautious.
Right, 419
Right,
is a
but if
definition.
you
and
want to
it-
clarify the 419,
Which is the definition.
This is what we're doing here. And so we're saying that a homeschool student means a student who is exempt from compulsory education. And that's in statute. And from what I've gotten the emails from the Utah Homeschool Education Association and Carrie Ann Lisenby, they said if we're going to do it, then just stick with what's in statute. And so, but that's what we're doing. We're sticking with what's in statute. That's what
we're trying to do here.
And strike out anything else that's not defined in statute.
I just think if we're going to go this route with just the funding, again, for me, it's that boiling pot water. It's just one more thing from what I'm seeing.
But
so all I'm saying is simplify it, pull the definition down so far that we're not adding to or trying to add to the law. That's all it is. So it's not what I mean when I talk about funding. I'm trying to talk about the student, right? Because the only reason why we care about all of these definitions is because we have to provide funding for the students, right? We have to make sure the funding gets to where it belongs, right? We care about the students, but we only care about what educational path they're taking is because certain funding flows in certain ways. And so to say, here is what it means to be a public school student. You're receiving MSP fund. Whoever they're enrolled with is receiving funding for that student on their backpack. And some students take a full backpack and some have a half backpack, right? And so we're just defining, here's a half backpack student, here's a full backpack student, and here's one who doesn't have one, right? Or who chose not to put one on, right? They don't want it. And so it's just, that's all I'm saying as far as the funding goes, is that we're not trying to expand the definition into instruction. We're not trying to get into what that means, because it's the place and all of that has changed, right? Homeschool used to be home and regular school used to be in a building, but it's changed over time. And so how do we define a public school student in a way that isn't about place?
Right.
So,
and I feel like these definitions, we do need some clear things and we need to follow the statute. But I'm glad that we're defining dual enrollment, because there are some districts that are telling homeschool students, if you want to dual enroll, you've got to take 2 courses. You have to take 3 courses. You have to take 4. Like they're saying, and the student can just take 1.
Let me comment. And just FYI, when we talked about these definitions yesterday, we had a couple of our LEA representatives who said they would appreciate 438 being reopened to, they actually appreciated, they felt like these definitions will be very key to being able to then talk about the policies moving forward, because they're grappling with those very issues of how much they'd like some forms that don't just completely exempt, but maybe a partial exemption for dual enrollment students, because they're feeling some liability. They raised some issues of test administration requirements, graduation rate,
Well, the
inclusion
only,
requirements, stuff like
because the
that.
dual enroll student is a homeschool student that goes to school half the time. So an LEA doesn't need to worry about a graduation rate for those students,
But it is
nor.
counted on them. They are counted towards their graduation rate. We
Why?
wanted
They're a
to-
homeschool
but that's
student
the point. We
exempt
could
from
talk about
compulsory
exempting
education.
them. We could do that if we brought up 438.
Okay.
Or saying the other issue is the assessment. Right now, our laws would require, so let's say a student's taking math, but they
Right,
don't
they would
take
be
English.
required.
Right now, they're required to take both. And the student's
Oh.
performance on both is attributed to LEA when the LEA is only providing the instruction in one. So we could clarify, I'm trying to say there's some
Right.
things you could clarify.
And I know that some homeschool students feel like if they're dual enrolled in a math course, then they shouldn't be forced to take the SAGE. And they've contacted me, I'm like, well, you're in there, you have to opt out of
Mhm.
SAGE because right now you are a public school student for that math course.
Right. And I think some of the reasons why you get that pushback from the LEAs is they are worried that if the student is dual enrolled, they now are attributed to their graduation rate. They will be part of their proficiency for their SAGE. But see, if we were to take those away,
Yes.
do you see where then probably
understand
some
now.
of what you're raising as a concern
Yeah.
would be solved? Because the LEAs would be like, oh, it's very clear. If Angie's son is doing math only, Angie's son will only count towards my school's grade on math,
On math,
and won't
right.
be part of the graduation rate. and stuff like
Right,
that.
because they're still
Yeah, so-
homeschool, they've still filled out that compulsory
Yeah.
education form. Okay, interesting, I didn't know that that was, okay, so,
So I move that we bring this rule back at a later date based on the changes that we have suggested.
okay, so the motion before us is to bring the rule back at a later date with, with the suggestions.
That'd be great.
Okay, all in favor? Aye. Oh, Laura's gone. Any opposed? Okay, roll pass unanimously. And we are done.
Angie, can I just ask if you had